Yes. To manage.
My lord, may I have my lord's leave to mention item number 346? Well, this time with a little hope, my lord. Last time lordship told me to come back after vacation, so I came a little late after vacation even. It is section 34. Both parties are ready, my lord. It will take only 15 minutes, my lord.
What is this? Which matter?
My lord, 346 of item number 346, my lord, of the monthly list.
Monthly list, sir? The award is of which year?
My lord, the award is of 2023, my lord. 15 minutes only, my lord. My lord, I have mentioned it quite many times. My lord, lordship said after vacation you come, I will list it. But I came little later after vacation so that, my lord, things are little
Difficulty
settled.
is that
15 minutes only, my lord. My lord, is a small time trader secured the money, my lord, of 7 crores, my lord. My lord, renewing it every year. It's been 3 years now, my lord. Really difficult, my lord. I would, my lord, express the actual difficulty, my lord. 15 minutes. Both sides are ready. He's also not able to take out the money.
on the other side.
My lord, any day subject to my lord's control.
Trilok Kumar Jha.
Yes. Any day lordships to my they are also not able to take it out because my lord, they are also
Guilties are not able to touch 34s.
any day, my lord. Any day, my lord.
With all the 11 and 9 and
11-9, I know lordship doesn't take much of a time. Even in 34, even 11-9 lordship doesn't take
but I'm
time.
not able to.
And any day, my lord, any day. I'm not saying, my lord, this week or any week, my lord. Even after 1 month, I'm comfortable, my lord.
We'll see.
Any day, my lord, at any time, my lord.
We'll see.
Please, my lord. Grateful, my lord. I'm deeply appreciative.
No, I also want to do 34s, but it's just
Yes,
not
I know, my lord.
happening.
I know, my lord.
Initially, we were able to do so many of them, but then after
Some of them are before my lord. Pathats, my lord, have started arguments, but thereafter they've gone into monthly list and
what to do?
difficult. Only thing, my lord, in that case, lordship will have to have a 34 day, my lord, half
But
day
you
or
have,
something.
you have exclusion, you
Exactly,
have commercial, you have non-commercial. It's
huge, huge. I understand, my lord. Commercial, non-commercial,
then execution,
then execution.
complete day for execution.
But any day, even after a month, my lord, I am happy with it. Both of us are suffering. Grateful.
Yes.
State matter item number 1.
Lordship's kind leave. This has come up at my instance.
Yes.
We had filed an application GA1 of 2026 in the section 34 petition. So we are the respondent. So I'm seeking leave to withdraw that application, Your Lordship. I have got the client's instruction.
What is the application?
Basically, Your Lordship, the application was for early hearing of the section 34, which was wrongly advised and filed. Thereafter, the client has understood, and after the conference, we decided to withdraw that application.
You're on the, you're for the petition.
They are the petitioner in session.
Learned counsel for the respondent GA kar dena. GA1 seeks to withdraw the present application. The same is dismissed as withdrawn.
Deeply.
Number 2.
May I please, Your Lordship? This has come from my instance, Your Lordship.
Yes.
Lordship, on 9 July, Your Lordship was
Yes,
pleased
yes,
to
that
the
para
client. Yes, Your Lordship.
Inadvertent error has crept into the order dated so and so, wherein in para 8, only one details of only one bank account is mentioned. The others have been inadvertently missed out. Add the other two bank account. The rest of the order shall be necessary. क्या हुआ इसमें ये अकाउंट आया है ये भी डालना है ये भी डालना है तीनों attachment to the tune of that amount which is already mentioned there earlier order that will be
Oblige, Your Lordship.
3.
And I am appealing for the petitioner, award holder.
Yes.
On last occasion, Lordship was directed to deposit or there is office report.
You have deposited the money?
They have deposited the money.
They have deposited?
Respondent judgment date have deposited the money. Amount to be deposited in interest bearing.
Take down. That is listed on classical order with an office note. The amount deposited by you have deposited the amount.
They have deposited.
The amount deposited by the petitioner to the tune of 50171,430 shall be kept in a interest bearing FDR with auto renewal facility. No other.
Matter will appear in the list.
It's already in the list.
Matter is tomorrow is likely to appear in the list.
23rd.
Tomorrow.
23rd, sir. 23rd.
23rd. Well, instead of 23rd, can we make it on 30th?
No, sir. 23rd.
23rd.
I'm for the respondent.
You have deposited the money?
No. They have.
My Lord, Aparna Banerjee appearing for the petitioner, Union of India.
This order karo. Office note. Matter listed on office note. The amount deposited 3 crore 50 lakh shall be kept in a interest bearing FDR with auto renewal facility. No further orders required. Disposed of, no?
Item 5.
This is my application under section 29A. Seeking extension of the mandate of the arbitral tribunal.
But I appear for the respondent, my lord.
Yes.
My lords, we do not object to such extension, my lords.
Any other extension before?
Twice we have, my lord.
Page number?
Kindly take notes of, my lord, the order passed, my lord, the first at page 55.
Yes.
And my lord, thereafter, my lord, at page 65, my lord was pleased to, my lord, extend for the further period of, my lord, for 8 months.
Take down. The petitioner has preferred the present application under section 29A of the Arbitration Conciliation Act, seeking extension of time for conclusion of the arbitral proceedings and publication of the award. What is the stage?
My lord, it's in the stage of final hearing, my lord. My lord, we have commenced, my lord, the hearing, my lord, they are yet to, my lord, start. Their
Learned
final
counsel for
hearing.
the petitioner submits
Yes,
that the parties, by mutual consent, constituted the arbitral tribunal which entered upon reference on 14/10/2022. This court, by order dated 21/11/2024, extended the mandate of the arbitral tribunal for a period of 1 year from the date of communication of the said order to the tribunal. Subsequently, by order dated November 12, 2025, the mandate of the arbitral tribunal was further extended for a period of 8 months. The tribunal learned counsel for the parties submit that the tribunal has had more than 50 sittings
50 sittings, my lord.
and the matter is at the stage of final arguments. Full stop. Learned counsel for the respondent states that he has no objection to the present application. Upon consideration of the materials placed on record, this court is satisfied that no delay in the conduct of the arbitral proceedings is attributable to the learned sole arbitrator. Full stop. Having regard to the advanced stage of the arbitral proceedings and in the interest of justice, the mandate of the arbitral tribunal is extended further for a period of 6 months.
My lord, not 6 months, my lord. We have just started, my lord, with the arguments, resumed with the arguments, my lord.
So how much time is the argument take?
My lord, we require, my lord, some time, my lord. My lord, the respondent, my lord, yet to start with their arguments, my lord.
8 months. 8 months from today, the sole arbitrator is requested to make all reasonable endeavors to complete the arbitral proceedings and publish the award within.
But I'm sorry to interject, my lord. My lord, it's a tribunal, my lord, of 3 arbitrators, not sole arbitrator.
Tribunal kar dena. Sole arbitrator or tribunal. The mandate of the arbitrator.
Grateful.
Tribunal is
Grateful.
reasonable endeavors to complete the proceedings and publish the award within the extended time period. With the aforesaid direction, the present petition stands. The arbitrator and tribunal.
Grateful.
Six.
My application under section 11 read with section 15.
My lord, I would like to use an affidavit in this matter. Here, my lord.
I will not come in the way if my learned friend wants to file an affidavit, but my lord will kindly consider prayer B because the arbitrator is more than 90 years and that's why he has recused himself. He is ailing. My lord, a preliminary award with regard to resolution of a partnership firm was passed. What was left was only accounts under 45 to 48 of the Partnership Act. Now, my lord, there has been various other proceedings. My learned friend wants to use an affidavit. I do not mind, my lord, but your lordship will kindly grant me prayer B. If your lordship kindly has a look at, if your lordship kindly comes to page 27.
Yes,
My lord, prayer B.
I can see that.
Yes.
But that is
Because my lord will kindly see the reason for his recusal. He says he is unwell, he is above 90.
Well, that is not the sole reason for recusal. Let me address your lordship on that, on affidavit.
No, but like the papers at least, if
Prayer B, my lord, if the papers are to be brought to the record of the court, I don't mind. But the application is not maintainable in my humble submission, my lord. There's been a hiatus of more than 14 years between the last sitting of arbitration and the petitioners, my lord, approaching the arbitrator to resume the proceedings. There is now a decision of the Honorable Supreme Court and the Bombay High Court, which says that this amounts to abandonment and deemed termination under section 32 of the reference.
nothing was happening.
Nothing was happening.
there were suits filed, the carriage of proceedings was by him. He was the claimant before the arbitrator. And my lord, abandonment, it's a question of intention and animus. Can that be decided in a section 11? And animus depend, my lord, upon.
They filed their reply then.
Please.
And in the meantime, my lord, prayer B. If you
No. No,
but the
there-
papers,
Lordship
my
will
lord,
decide
the
the
papers
maintainability.
get.
Not that is like literally giving a direction that the arbitrator is changed. That's like substitution.
No, let that be kept with the
Why should
register.
that be?
My lord,
That
Supreme
means that
Court's-
I'm already have made up my mind that the arbitrator is changed.
Great,
I'm
my lord.
substituting the arbitrator.
No,
the moment
because
I give a direction,
your lordship is not
the
substituting the
moment-
arbitrator.
the moment I'm taking any documents away from the arbitrator, what does it amount to?
My lord, my lord,
What does it
kindly,
amount to?
my lord will
It
kindly,
amounts to only one thing.
my lord,
That
kindly
this court
comes
has
to
lost
page
faith in the
187.
arbitrator. I can't do that.
My lord, it will go back to him because
sorry.
he says I am not in a position to, because they also
all
filed
right.
a section 14 before
That's
the
all right.
arbitrator.
We might change the arbitrator. We'll see that.
Right.
But that is like literally deciding the mandate of the tribunal. Whether
My lord,
that
because
exists
he has
or it doesn't
already
exist.
recused himself.
My lord,
It
I
is
would
not
take
that
10 days to
case.
file the affidavit.
My lord,
After that,
he has
we should
already
decide the
recused
matter.
himself. If your lordship kindly takes one document, page 187, because that's why under 15.2, he has already recused. I am not asking for removal. Unlike section 14, if your lordship kindly compares 14 with 15.
But the vehemence at this stage perhaps is not
My lord,
warranted.
I am not
Can be
saying so. I am
decided
not
after 10
saying
days
so.
on
I
affidavit.
did not object, Mr. Shah. I did not object when you wanted to file an affidavit. My lord, will
Yes, tell
kindly
me.
come to page 187A, my lord. That's the typed copy. The last. the last line. And whether I, at my 90 years plus age, with failing health, mobility constraint, doing so, but it means to suggest that not possible in proceeding with the matter. My mental health has deteriorated. I regret I would not be in a position to take up the matter for further proceedings.
My lord,
It
let
is
the
not a section 14 stage where I seek for removal. It is section 15 stage. If your lordship kindly looks at, there is a difference between
My lord, I'll
14.
request my learned senior friend to place
Let
the
me
entire
finish.
letter.
Yes, then I will. I'm not shying away. With reference to your letter, you were the claimant. What were you doing? You have hijacked, you have taken away the. I'm sorry, my lord.
Not in my court.
No, I had a sore
No need
throat.
for that.
No, my lord. I will.
Absolutely
I'm
no
sorry.
need for it.
I'm sorry.
Mr. Rudraman, there's no need to unnecessarily.
No,
You already have a throat ache. Unnecessarily, you'll aggravate it. What's the
I'm that's.
Yeah.
Will kindly take section 14 and section 15 once. This is not a. Because they themselves had filed as application under section 14.
15-2, right?
14. My lord will kindly look at 14 once.
Yes.
The mandate of an arbitrator shall terminate, and he shall be substituted by another arbitrator. Then your lordship is substituting the learned arbitrator. A, if he is de jure or de facto unable to perform his functions, or for other reasons fails to act without undue delay, and he withdraws from his office, or the parties agree to the termination of his mandate. If a controversy remains concerning any of the grounds referred to in clause A and of subsection 1, a party may, unless otherwise agreed by the parties, apply to the court to decide on the termination. But here your lordship is deciding on termination. Now, if your lordship kindly looks at section 15,
Yes.
in addition to the circumstances referred to in 13 or 14, the mandate of the arbitrator shall terminate when he withdraws from office for any reason or by pursuant of agreement. So, my lord, here the mandate has already gone because the arbitrator himself has recused. Now, the question arises whether a substitute arbitrator can be appointed because of this hiatus, as Mr. Shaha says, of 14 years. My lord, that is to be decided. So at this stage, since he has already withdrawn from the office, I was only beseeching your lordship, let the papers of the arbitral proceedings be kept with the registrar of the and prayer B be granted. I am not asking your lordship to substitute the learned arbitrator, which would have arisen in a situation under section 14. But here we are in a situation under section 15 where he has already withdrawn from his office.
See if it can be substituted or it has already been given up. If it is abandoned, then it is abandoned.
But abandonment, my lord, in my respectful submission, is a question of animus which needs to.
We have to decide that.
My lord.
That has to be decided only after exchange of affidavit. Can't be decided today. So, for the time being, let the documents remain with you. Must be having your own file. As far as the documents are concerned, it is not something which is only privy with the arbitrator and you don't have a copy of that. And if you don't have it, you ask for it. Get a certified copy from the arbitrator today and keep a file with yourself. You can apply for a certified copy. The arbitrator will give you. The present application has been filed under section 11(6), read with section 15(2) of the Arbitration and Conciliation Act 1996 by the petitioner seeking appointment of substitute sole arbitrator in place of Honorable Justice Arun Kumar Datta, retired, who has expressed his inability to continue with the arbitral proceedings. Full stop. Learned counsel for the respondent states, raises a preliminary objection that the present application is not maintainable since the petitioner had already abandoned the arbitral proceedings. He seeks and is granted liberty to file affidavit in opposition within a period of 2 weeks. 2 weeks? Reply, if any, within 1 week thereafter. After,
In 10 days, my lord, because the
within further time of 10 days?
My lord.
10 days? List after 4 weeks.
grateful.
5 weeks. List after
Great.
5 weeks.
Grateful.
Now 7.
My application, my lord, under section 11, my lord. Let us-
That I'm not seeking an agenda. That is on lakes input in respond mother. In case he's not able to, he could respond at another date, but I don't oppose my.
This is a section 21 notice has been given on the ground, my lord, the challenging the wrongful termination of a sublease, which has been granted by the respondent in favor of my client. my lord.
Pleadings are complete in this.
Yes, my lord, pleadings are all complete, my lord.
What is it, section 11?
Yes, section 11, my lord.
You're opposing?
Yeah, there's a specific bar in the statute.
That public premises, their only defense is
71.
West Bengal premises eviction of unauthorized. The same perimeteria with the Central Act, my lord. Kindly see my section 21 notice, page 120. I am the sublessee, my lord. They have terminated my sublease. I have said, my lord, this termination is wrongful and I have a claim for damages. Kindly see, my lord, just a brief facts which I have narrated here in the 21 notice. The para 2, RIT-SPL and my client entered in a sublease agreement with yourself on 4th July. As per said agreement, Department of Information Technology Electronics, Government of West Bengal was the sublessor and RIT-SPL was the sublessee. Was for 99 years. RIT-SPL has made payment of 6 crore 5 lakhs at the request and direction of Department of Information Technology as recorded in a sublease agreement. We have paid a total lease rent of 27,600. Under the agreement, we had to construct necessary building structure installation for IT and ITS and electronic industry within a period of 60 months from the date subject to terms and conditions. As per the terms of the agreement being clause H of second schedule, the Department of Information Technology was required to provide power supply, adequate water line connection, sewerage outlet. But that clause is set out in para 5. Even before 15 September 2010, when the Nonadaga IT Park was inaugurated, RIT has already taken steps and erected boundary pillars and had completed fencing, which was allocated to petitioner under the agreement. In terms of clause H, RIT-SPL had submitted architect's plan drawing for construction to the principal secretary as evidenced by letter dated such and such. By way of same letter brought to your notice non-availability of power supply, adequate water line connections which must be provided. Till date, architect's plan and drawings have not been approved. Then, my lord, para 8, severed by written communications, RIT requested for power supply point. This is in 2017, continuing. Up to 2017, my request is there to provide the power supply point, adequate water line connection, sewerage, which will be provided by sublessor. Allegations made in the letter such and such by the Department of Information Technology that no construction is till date and thereby breach the term is an absolute false. It is deliberately made by suppressing vital fact that the prior obligation has been breached. Then, my lord, But I'm not going in detail because the merits your lordship will not be concerned. Then, my lord, straight away, if your lordship kindly comes to para 12 at page 122. Sorry, para 11 at page 121, last para. Suddenly, after a silence of 5 years, Department of Information Technology, Government of India issued letter dated 20th September 2023, gave notice of revocation of the sublease. So this is the starting point of the dispute. And para 12, I have disputed this. The letter dated 20th September giving notice of revocation is illegal. Letter itself is a breach of the terms and conditions of the agreement. Then, my lord, my disputes I have narrated, kindly come to page 123, para 18. The sublease deed contains the arbitration clause. As a result, RITP is invoking the arbitration clause inter alia entitled to the following claims. Declaration that the letter dated 20th September 2023 purporting to revoke the sublease is illegal and void. Direction to department to comply with clause H of second schedule of the agreement. Declaration that the invocation of indemnity bond is void and invalid. Permanent injunction against department from interfering with the rights of RITPL under the agreement. Award for damages. So this was, my lord, and I had nominated such and such as my nominee, my lord. Then, my lord, your lordship will kindly see their reply to this. Page 124, my lord. Now, before this, I must also tell your lordship, my lord, before this, they had issued a notice dated 17th October 2023 under section 3(1) of the Act, which is at page 96.
Which is the letter after 5 years. Is that the letter after 5 years which you're talking about?
Yes, my lord. No, that is after termination, they issued this notice again.
All right.
They are saying, kindly see, notice under subsection 1 of section 3 at the top, page 96. To my client, whereas an application has been made before me by Information Technology Electronics Department under subsection 1 of section 3 of West Bengal Public Land Eviction of Unauthorized Occupants Act, that you have been in unauthorized occupation of the public land. Now, therefore, in exercise of the power conferred by subsection 1, I hereby give you notice to appear before me personally, such and such. So they try to initiate the proceeding under section 3 of the West Bengal Public Land Act. Then, my lord, I have filed a section 9 proceeding. Section 9 proceeding, these proceedings were stayed. They went up in appeal before the division bench. Division bench has dismissed the section 9 on the ground of territorial jurisdiction. There is no comment on the validity of the proceedings or invalidity of the proceedings. That has never been decided. So we have thereafter section 21 followed by now the section 11 is there. Now the only question, my lord, which arises in the context of a section 11 is, what is the court, my lord, what is the power of the court to look into when a section 11 comes? Number one, my lord, that there is in existence an arbitration agreement. Number two, my lord, the disputes referred for arbitration in the section 21 notice are covered by the scope and ambit of the arbitration agreement, and those are live disputes. Now, my lord, therefore, these are the three issues which fall for consideration here. What is their response to my section 21? Their response, my lord, is there is a act which they have invoked for the purpose of eviction. At the most, my lord, that they are saying there is a parallel remedy which I have.
But that is only for the purpose of taking possession of the property. What about the other disputes?
Absolutely. So that is my case. Even assuming that you have a right under the Act, you proceed under the Act. My lord, I am not here to stall that proceedings. Today, if suppose, my lord, I have a claim which they feel arbitrator may not have jurisdiction. then it is again, my lord, section 16 remedy. Today they cannot come to the section 11 court and say there cannot be any arbitration in respect of the disputes raised under the section 21 notice. That they could have said only if they can say that there is no arbitration agreement at all. There is no dispute which is live. These are the only two issues which that they can raise.
Where's the main agreement?
My lord, I'll show you. Sublease agreement is
Page 15.
1-5, my lord.
Arbitration page 28.
Kindly come to page 28. Parties shall make every endeavor, clause 5, to settle any dispute, controversy, or claim arising between the parties in connection with this sublease amicably in the spirit of good faith. In the event of failure to do such dispute, controversy, or claim shall be finally resolved in terms of the Arbitration Act as amended from time to time within the jurisdiction of the Kolkata High Court. So there are absolutely broad arbitration clause, and all my disputes are covered by this clause. Now I just show your lordship what is their reply to my section 21 notice, my lord. Kindly come to paragraph page 124. 124. Paragraph 9 will be relevant, my lord. Up to paragraph 8 is, my lord, their case of my breach or their breach, whatever it is, my lord. I read from para 8, in such circumstances and in view of breach of sublease by you, our client was constrained to issue a letter dated September 20, 2023, determining the sublease, calling upon you to hand over vacant and peaceful possession within 7 days. Despite this, you have continued on wrongful and illegal possession. In view of your non-compliance with the letter dated such and such, our client was constrained to initiate proceedings against you under section 3 of the Public Land 1962 Act. Before the LA Collector, you have entered appearance, subjected yourself. It is stated that the issue of your continued lawful occupation can only be adjudicated in the said proceedings. Same cannot be the subject matter of arbitration. This is what their case is, Bullet. Issue of your continued unlawful occupation of the property, including consequential issues pertaining to determination of the said sublease, can only be adjudicated. But there, Bullet, I join issue. If your lordship sees, they can only, the only powers under that act is, I am an unlawful occupant, where a termination notice itself is in dispute. That issue, whether termination is legal or not, that cannot be decided by the authority. Termination is in terms of the sublease. Sublease is a contract between the parties. Contract contains the arbitration clause. Whether I have breached or not, or my breach, if at all, is dependent upon your breach, this does not fall within the domain of the authority under the 1962 Act. This has to be decided by the arbitrator. Then, my lord, once termination is upheld and the person is unlawful possession, lord, if I may hand over a copy of that Act 62 Act. Kindly see the scheme of the Act. Kindly see the preamble at the top. Act to provide for speedy eviction of unauthorized occupant. Provide for, whereas it is expedient to provide for speedy eviction of unauthorized occupant from the public land. Then kindly see in the definition clause 2.8, unauthorized occupation. Unauthorized occupation in relation to any public land means the use or occupation by any person of the public land without authority in writing by or on behalf of the owner thereof, and includes continued use or occupation of any such land on the expiry or termination of such authority. So it only decides the matter that the person is in unauthorized occupation. Kindly see section 3, my lord. 3.1. Issue of notice to show cause. This that show cause notice which was issued. If in respect of any public land, the collector is of opinion upon application made by an officer of the owner of public land authorized in this behalf by such owner or upon termination or information received otherwise, that the public land is in unauthorized occupation of any person or persons. So that is a jurisdictional fact based on which the collector will start his exercising his jurisdiction. Now that jurisdictional fact, whether I am in unauthorized occupation or not, is dependent upon adjudication of the issue of termination, propriety of termination. He cannot decide the propriety of termination. Before him, termination is there. As a matter of fact, it exists and a person is overstaying there. So that jurisdictional fact is absent here. Because a proceeding has been commenced by issuance of section 21 to determine the propriety of termination. And that propriety of termination is governed by the arbitration clause. So, therefore, my first prayer in my 21 notice forms the subject matter of the arbitration clause, which is a live dispute. So, this is my very short submission, but I'll just, for completeness, I'll just show there is a only this is well known, my lord, lordship's contours in a what will your lordship see in a section 11. My lord, that is this judgment. This is 2025 SCC online SC 1098.
Which one? Rolia?
Ercon International, my lord. Ercon Infrastructure. Kindly see paragraph 6 and 7. The short question that calls for a consideration whether while exercising power under 11 of the 96 Act, the court has to confine its consideration as to the existence of an arbitration agreement between the parties. If so, whether it would be permissible and while exercising jurisdiction to hold that some of the claims raised are non-arbitrable or fall within the accepted category. Subsection 6A of section 11, which was inserted by Act 3 of 2016 with effect from 23rd October, makes it clear that while considering an application under subsection 4 or subsection 5 or subsection 6, the Supreme Court or the High Court, as the case may be, shall, notwithstand any judgment, declare, order of any confine to the examination of existence of an arbitration agreement. Then, 11 and 12, your lordship will see. Then, para 10 also. The significance of the use of the expression "not other issues" in the statement of objects and reasons of the 2015 amendment was noticed by a 7-judge bench in re interplay, and it was observed. The above extract indicate that the Supreme Court or the High Court at the stage of appointment of an arbitrator shall examine the existence of prima facie arbitration agreement and not other issues. These other issues not only pertain to the validity of the arbitration agreement, but also include any other issues which are a consequence of unnecessary judicial interference in the arbitration proceeding. Relying on the above observation made by this court, a 3-judge bench of the court in SBI General Insurance observed, para 114 is quoted, that the scope of inquiry at the stage of appointment of arbitrator is limited to the scrutiny of prima facie existence of the arbitration agreement and nothing else. For this reason, we find it difficult to hold that the observations made in Vidya and adopted in NTPC, that the jurisdiction of the referral court when dealing with the issue of accord and satisfaction under section 11 extends to weeding out ex facie non-arbitrable frivolous disputes, would continue to apply despite the subsequent decision in interplay. As the above decision has been rendered by a 3-judge bench of this court after considering a 7-judge bench decision in interplay, We are of the view that the respondent cannot profit from certain observation in to judge very MR Sutra. Therefore, the High Court fell in error because in bisecting the claim of the appellant into two parts, one arbitrable and other not arbitrable, when it found arbitration agreement to be there for settlement of dispute, the correct course was to leave it open to the party to raise the issue of non-arbitrary before the arbitral tribunal. If they feel my termination claim is a non-arbitrable claim falling within Public Premises Act, that is to be raised before their my lord. Now, my lord, regarding this particular act, my lord, there is one. Yes, there is a two coordinate bench of our High Court, my lord, and also, my lord, the Supreme Court in the Central Warehousing Corporation matter, which says that both the acts operate in different fields. There is no dichotomy. This is, my lord, 24 SCC Online SC 2983, para 2. The question of law formulated in this appeal is whether Public Premises Act 71 overrides Arbitration Act. If the said question is answered in negative, the only question that survives is whether the High Court committed an error in appointing the arbitrator while exercising jurisdiction under Section 11 of the Act. Having examined the matter, it is clear that the question does not arise in the fact we are guided by the existence of the arbitration clause and the decision of this court in SBI General Insurance Company versus Krish Spinning, which discuss the scope of referral court's interference when a valid arbitration clause exists. Kindly come to, my lord, paragraph 13. Whether the first question, whether Public Premises Act 71 overrides the Arbitration and Conciliation Act 1996. The submission has to fail. The reasons are simple and straightforward. The dispute that is raised in the Section 11 application relates to promises and reciprocal promises arising out of the agreement dated such and such. The right of renewal as well as legality and propriety of the enhanced demand.
The last line.
Yes, the Public Premises Act, exactly, would
Just
not
need to examine the existence of an arbitration agreement. The context is clearly delineated.
neither bars nor overlaps with the scope. Obliged, my lord. Then, my lord, yes, my lord. So this is the position settled by the Supreme Court. Then, my lord, following this, my lord, we have two judgments of our coordinate bench, my lord. One concerning this West Bengal 1962 Act. These are the two coordinate bench. Oh, okay, diye dao. Kindly come to page 2. In any event, that paragraph at the top, it is noticed that a coordinate bench of this court in the order dated I'm sorry, my lord, I am reading
Yes,
Bhagwan Das Vehicle Test Services Limited versus West Bengal Transport Infrastructure.
Yes, in any event,
Yes,
it is
yes,
noticed that a coordinate bench of this court in an order dated
has
29.
recorded 3 plinths of objection of the respondent. The first was that the matter pertains to a special statute and as such is not inherently arbitrable. Second was that the words used in the agreement do not afford reference. Those two are not concerned. Then, my lord, kindly come to the operative part. Page 4. Looking, well, the paragraph starting with looking into the facts of the present case. However, it is clear that the dispute raised by the petitioner, it is noticed under Section 21, revolves entirely around the alleged unlawful termination of the concession agreement between the parties and the rights and liabilities flowing from the said concession agreement itself. The dispute resolution clause under Article 16 of the agreement covers all disputes of the present nature. That is what, my lord, we are also saying. The objection in the present case as to non-arbitrability on the ground of applicability of the 1962 Act is, although attractive at the first blush, otherwise spacious. The present dispute does not relate in any manner to an eviction proceeding under 62 Act. Although collaterally the outcome of the present dispute might affect the fate of 62 proceeding, the conspectus of applicability of 62 Act is in no manner germane in the present dispute. In the proceeding under 96 Act, reference is based entirely on the perception of the claimant as regards the nature of the dispute, which can subsequently be supplemented by statement of defense or counterclaim. At the stage of deciding an application on Section 11, it is the perception of the claimant as regards the dispute which is of paramount importance to the court. The court under Section 11 does not decide even prima facie on the merits of the dispute between parties, only has to see whether the dispute raised by the proposed claimant comes within the ambit of the arbitration clause in the agreement between the parties. Thus, question of applicability of the bar under 62 Act does not arise at all, since the Act pertains entirely to eviction proceedings against unauthorized occupants and removal of unauthorized construction in respect of public or government land. Dispute raised by the petitioner, however, has no nexus with such an eviction proceeding. Petitioner seeks to remedy the perceived wrong in termination of the contract between the parties. That apart, rights and liabilities claimed by the present petitioner all flow from concession agreement, do not in any manner relate to 62 Act proceeding, which might have been initiated by the respondent. Proceeding under 62 Act and the present referent operate in distinct and different fields and have no overlap or conflict with each other. At best, petitioner can set up a defense on the basis of the concession agreement in the 62 Act proceeding, in which case the said issue would only be incidental. Undoubtedly, 62 Act deals with matters on the state list of the 7th schedule of the Constitution, whereas 96 Act covers matters within the union list. Thus, there cannot be any comparison or conflict between the two vis-a-vis the present dispute. The present dispute has no nexus with the 62 Act, which is a special statute having no operation in the context of the present dispute. Thus, even without going into the question as to scope of an applicability of the 62 Act, which shall be decided by an approval, the present dispute, at least prima facie, pertain to concession agreement rights emanating therefrom, as such is fairly arbitrable and comes within the ambit of the arbitration clause. So, my lord, this is the Section 11 petition was ultimately allowed.
Yes.
The other objections, my lord.
Interesting, Mr. Sen, your argument in the other matter.
Yes, I was about to come to that.
Share health, huh?
My
Contrary
argument has been so that judgment also, my lord, paragraph 7, recording CWC, my lord, Central Warehousing Corporation, has been fully quoted, and on that basis, it is operating in different fields. There is no predicament to appointing of the arbitrator.
Yes.
চলে এসছো ওখান থেকে? These are my short submissions.
Yes.
I can just take.
Can I come about? Yeah. Because the point which Mr. Sen is arguing,
Isn't it settled? Isn't it settled? The point which you are trying to.
initially, before it was settled, I took that point in this proceeding also. But Mr. Sen was wiser because he got an opportunity, he got this point settled in another proceeding, and now he's having. But the question which I'm trying to argue to your lordship here is this. Your lordship will find that if the parties are to be referred to arbitration under an arbitration agreement, then that arbitration agreement should be a panacea to the problems of both the parties. It cannot be that so far as the Mr. Sen is concerned, the arbitration clause is good. But so far as the dispute which I raised, the arbitration clause does not apply. Because the situation here is little like this. I'm sure my learned friend has taken your lordship to the fact, so Villa was not there. We granted him a leave, Villa, we have terminated him. The reason for termination, apart from other grounds, is that we have come to know that Mr. Sen's client, without obtaining permission from the government, or let's take my client, has actually mortgaged the property to a bank. In respect of dues of another company, of his another company in Bombay. He says he has permission, but the document which he shows does not have permission. Now, in course of this litigation only, we came across two letters signed by the minister in charge at that point of time. One which says, no, you cannot do it. You can obtain a loan only for investing in West Bengal. And the other which says, and for, there is one three line, and for other reasons. So, my lord, a complaint was lodged that investigation is going on, criminal proceedings. But I am not on that. Today, I had sued him for eviction in that proceedings before the authorities. So my grievance is that you give me possession. But the fact remains that under the SARFAESI Act, for non-payment of dues, the bank has taken possession. That's a separate proceeding. Correct. So therefore, if I am to institute a proceeding for SARFAESI, I cannot today ask him for possession. Although I have to get a decree for eviction against him to say to the bank that give me possession. That decree for possession, that decree for eviction, in the proceeding, in that same proceeding, there cannot be a decree of handing over possession. I can get a decree of eviction here, but I cannot get an order for possession. So, my lord, when I go to execute that decree, the bank will say that I was not a party to that arbitration. So, it's not binding on me. So, the question is, and that is what I will address your
But that is only one limb of the argument. See, as far as the disputes are concerned, it is not only confined only to the possession or who's in possession and who's going to take the possession. Suppose you have a counterclaim. You have a counterclaim to the extent that he was not supposed to sublease the property which he has done, causing loss to you. Suppose you have a counterclaim. I'm not saying that you have, you don't have,
will have a claim,
but you can have a counterclaim.
and I'll ask for
Say
eviction.
his claim, he has a claim to the extent that the lease has been
Wrongfully
terminated, he has suffered damages. That has to be, it is something which is arbitrable.
It's arbitrable.
It has to go before the arbitrator to decide. As far as your possession is concerned, that is something which you are doing under the 1962 Act. You take possession of the property. How you take possession of the property is under the separate provision of the. But as far as the arbitration is concerned and the claims are concerned, there is a claim.
So, Millard, what I understand is this, that
now whether you were supposed to provide water,
both
whether you were
acts
supposed to provide electricity, whether you have done it, you have not done it,
decided in the
whether
damage claim, yes.
the letter which you had written in September of 2023 is correct, not correct, all that is to be decided by the arbitrator.
So, Millard,
This court can't get into it.
no, I'm not inviting the court to go into this.
Right? So you're not
point
denying,
which I'm trying
you're
to
not
explain.
denying the agreement, the sublease which you have entered into.
Of course not, Millard.
Right?
Of course not. Because
A
other
payment which has been made, an arbitration clause which is there. There are disputes.
I am not disputing once, Millard. What I'm trying to come to, Millard, the point which I'm trying to drive home is that the appointment of the arbitrator will not prevent me from, because the court has said the two acts are different.
Absolutely.
So that one line observation, I go to arbitration.
That is a separate proceeding altogether.
They give me a moment. Now, section 11 is arbitration. Regarding the agreement. Oh. Well, in my usual, I forgot that I was appearing for the state. I can't consent to anything. I don't have the authority to consent. So, Millard, this is the crux. What I was trying to, but I cannot consent to Millard with the application. But my proceedings before the CID are also pending, Millard.
That's all right.
I think, Millard, if that can be an observation that since the acts operate differently, that does not prevent me from going to and proceeding. I can't consent, but I leave it to your lordship.
Any other, you want to rely on some judgment or something? No.
That would be not. I'll have to hold back the court for a day.
You want to come back? You come back tomorrow, day after tomorrow.
Yeah. Yes.
Or come back on Monday.
Whichever.
Heard. Heard. Learned Senior Counsel, Shaku Sen. List for further hearing on Monday.
No, 8.
Lord, item number 8 is my application for appointment of an arbitrator. Lord, this matter pertains to a contract with the Southeastern Railways.
Who's appearing? You're appearing?
I'm led by Mr. Ghosh.
My Lord, in this matter, my Lord, this is a section 11 for appointment of the arbitrator. My Lord, the reason I have come before, or the facts which have led me to come before this court is that, my Lord, here a tender was floated. I had participated, and on 4th, this notice inviting tender was floated on 4th of September 2023. I had participated, and a letter of acceptance was issued on 28th of December 2023. But one reason why I indicate this is because there is a general conditions of contract which is applicable now with regard to the provision of appointment under the GCC, which is 64. That 64.3 in our case, I would get into specifics as I proceed with the argument, whether that is applicable or not, and the manner in which it has been altered. My learned friend has issued letters based on communication by the railway authorities themselves subsequent to the disputes having arisen, that there has been a correction slip issued, and in terms of the correction slip, the particular procedure for appointment has been laid down, whereas the date on which the contract was entered into and the applicable provision as on that date, on the basis of which mutual consent was given and the parties had agreed, that would be material, which is why I'm chronologically going with the dates here, my lord. So, my lord,
Before my friend, my lord, wasn't chronologically, but with explicit communication, they have accepted the offer. But kindly once peruse the communication made by the in terms of the GCC, they have chosen to appoint name
of two arbitrators from the ICA panel, and we are agreeable to that.
my lord, no
They have given,
communication. Sorry.
they have given two names in terms of the guidelines, and it is agreeable to us, my lord.
My lord, I would have come to this. My lord, the issue is, my lord, this letter was issued before the matter was taken up before my lord. And on that date, I had come and indicated this letter to my lord that this has been written by me. My lord had opined that this particular clause could not have been operated, and I couldn't, if unless I come with a consent and a terms of settlement, this letter is of no meaning, and my lord will hear out my application. My lord, from the very first day when I had moved this application, I have been opposing the particular clause, but there is some dispute with regard to a particular marking of waiver or not waiver on my account, on the basis of which the court, having the previous determination over this matter, had opined that I have given my consent and I had given my waiver in terms of 12.5. But subsequently, with the change of this attempt to bring in the ACS 10, I will show from each document chronologically that no, the parties have, there was never consensus ad idem or consent between the
If you have
parties.
given a waiver, then
My lord, I will indicate there was no waiver. And that is what my learned friend has also
Your Honor,
understood from their document. But when they had argued, indicated one specific letter where I should have struck off a particular line. Instead of striking off, I have ticked that place.
No,
But
not only
in the
that.
subsequent letter issued by them, they have understood it that I have not given waiver. It is in their affidavit of opposition itself. My lord, even otherwise, I am on only one thing. Today, there is no dispute with regard to the arbitration clause. My lord, 64.3 indicated under the previous, the GCC, which was applicable, the sixth, as of the sixth ACS, which was applicable on that date, there was a particular clause with regard to if claims go above 50 lakhs, it will be before one particular arbitrator in case of non-waiver, and if it goes above 1 crore or above 50 lakhs up to 1 crore, it will be before 3 arbitrators. The issue that was there on the very first date when we moved the matter was whether we can go before one arbitrator because the claim was only 70 lakhs. Even on that date, there was an understanding that the arbitrator, even today, there is an understanding there is an arbitration clause. Who would be the arbitrator and under what provision it will be appointed is the main question. Whether ACS 10 can be applicable, what would be the effect of the judgment on 8th of November 2025? That is the mere effect. Because even today, my lord, the document that my lord has been handed over to my lord relates to the applicability of rule ACS 10, where ICA, the institutional arbitrators body panel, has been identified. If that particular clause is not made applicable, then it does not apply to, or rather would not apply to my consent as well. So, my lord, may I just show these letters one after the other, and thereafter I will leave it to my lord for the purpose of appointment, because and the quantum. This is the main issue in the matter. My lord, the reason why I'm indicating 28 December 2023 is because the GCC which was applicable had been published on 21st December.
The order dated 9th of
9th of April, my lord.
December. 9th of December, right?
My lord.
Where the observations are there.
Oh, yes, my lord.
The matter requires further hearing. Prima facie view of the court is that the respondent had waived the applicability of
my lord
section 12.5.
My lord, now I can show that go to the document directly, or my lord, I can show chronologically. Well, I'll take my lord to the particular document. My lord kindly takes up my learned friend's affidavit.
And my lord once takes up page 99 of their communication of the application. Page 99 once.
You will get the opportunity. Yes.
My lord kindly takes up the affidavit. My lord, here what happened was, my lord, before my lord, just brief 2 lines of facts. My lord, here there was a contract entered. I was supposed to do perform a particular duty. I failed. A notice of termination and blacklisting was issued on me. I file a writ petition. The writ petition is dismissed because it relates to commercial transactions between the parties. The matter travels to the division bench. The division bench indicates that whatever disputes within 10 days, you write to the authority. They will take steps in terms of the arbitration clause. So this letter, the order was passed on 8th of April by the division bench. On 17th of April 2025, I have filed the my claim statement before the authority. After this has been filed, my lord will find that document. It is annexed to the affidavit. It starts at page 70. My lord, sorry, it starts at page 13 onwards. And after that document is the next communication with regard to the waiver. Page 13 is the first document. Page 23 is the waiver document. My lord will see The first page is with regard to annexure Roman XV 15, and my lord, the first page is with regard to the railway authorities statement. And here, my lord, in the second paragraph, they have struck off do not agree to waive off the applicability. And my lord, I want to highlight the fact as well at the bottom of the page on the left side, my lord will see with a asterisk mark, strike out whichever not applicable. So this was the norm, and my learned friend's client had struck off do not agree. My lord, on the next page is my signature on the same document. And my lord will find similarly on this, my lord is at page 24, my lord. Sorry. My lord, at page 24, my lord will find I have not struck, my client has not struck off, rather he has put a tick mark under do not agree. That is what his understanding was.
You have cut off the knot.
Yes.
My lord has cut off the knot. I'm with my lord. There is a line. There is a line. And there is a tick in the bottom as well. Now,
I do agree.
my lord, yes. This is the document. This is what caused the confusion as well.
Not confusion.
My lord will kindly see now their communication. Where is their communication? My lord will kindly see their communication at page 35 now. 23rd May 2025. My lord, from the affidavit I'm showing. Page 35, 23rd May 2025. Kindly my lord, I'm reading the body of the letter. This was issued to the director of the petitioner. Kindly refer to your above letter where you have mentioned GCC correction slip is not applicable in your case. So this is referring to the ACS 10, and you have submitted waiver with condition do not agree. Department has confirmed that GCC 2022 is applicable in your case. So there is a issue, my lord. Now this has I will come clean and I will indicate to my lord. This is with regard to application of ACS 10. This is what has been construed. But my lord, at all stages, even from my previous correspondence, where my lord will now kindly go back one step, and at page 33 is my previous letter of 9th May 2025. Page 33, my lord, of the affidavit itself. This is the previous letter. My lord, here I had appointed 3 retired judges from the panel of the Indian Council of Arbitrators list. And I had, my lord will kindly see at the second page of the letter, page 34, I had indicated that so far as the GCC correction slip 10 is concerned, this will be prospective and would not be applicable in my case. Now, my lord, with regard to waiver or non-waiver, I am not arguing or trying to place my case before my lord. My lord, because if my lord takes up GCC of as applicable on 21st December 2023, which is according to me the applicable GCC, I believe I had handed over a copy. I will hand over another copy of the GCC. Ashik. My lord, the GCC, my lord will kindly take up the GCC. My lord will see this is from applicable from 13th December 2022, and it has been updated up to ACS 6 dated 21st December 2023. This I have checked up, my lord, and the particular copy, my lord, will kindly come to page 98. Sorry, My lord, there the appointment with regard to arbitrator clauses are there. That is where clause 64 starts. My lord will kindly see that appointment of arbitrator. My lord, there are two clauses here now. 64(3)(a). This is with regard to when waived off. So there is applicability of 64(3)(a)(1) and (a)(2), which the difference is the quantum, my lord. And with regard to 64(3)(b) is in case of not waived off. I am placing all the circumstances before my lord, and my lord will decide in terms of the waiver. My lord will decide. I will not argue that point. Only which will be applicable, my lord will kindly consider. Now, my lord will see 64(3)(b). Again, the quantum is the difference. There, the quantum was 1 crore. Here, the quantum is 50 lakhs. Anything below 50 lakhs, sole arbitrator. Anything above 50 lakhs, 3-member panel. When I had filed my application, it was under the impression that this document in the affidavit was not to my knowledge. It was under the impression that 70 lakhs would go to a 3-member tribunal in case of not waived off under section 64(3)(b) Roman 2. So this was my initial argument, and that is what my petition was about. And my lord, with regard to the later part of all these 4 clauses, my lord will see that this refers to a panel of retired railway officers, which is why these personals could not have appeared as arbitrators. My lord, there is a decision of the Supreme Court of 8th of November 2024, and in that these clauses have been struck down. My lord, this is the decision. And I would also show to my lord that the
waiver will not cover that.
My lord,
your waiver will not cover that.
No, my lord, I am not arguing on waiver. I am not.
You are arguing on that.
No, my lord, I am only trying to indicate to my lord that the particular.
Once you have given the waiver, where is the question of this court interference?
My lord, what I am trying to argue is subsequent to these waiver, the waiver document which my lord has seen. After the waiver document, they have issued a letter and they have indicated.
Not see that letter at all. I only need to see your waiver.
My lord sees my waiver.
I did not see any other document except your waiver. And your waiver is absolutely clear. And prima facie, this court is of the view that you have given a waiver.
Indeed. My lord, I am not arguing waiver.
Then where is the question of this court appointing the arbitrator?
My lord, the arbitrator appointment, my lord, now my only dispute today is whether the arbitrator appointment has to come in terms of the correction slip number 6 or correction slip number 10, because my learned, which my lord I had already indicated that I have not agreed to correction slip number 10. My lord, the correction slip number 10 would take me to a list by the rules of International Council of Arbitrators. If I do not fall under ACS 10 and I fall under ACS 6, which was applicable on that date, the particular grounds of appointment, these persons are reject or not eligible to be appointed, the court has to appoint any person. Insofar as the personnel of the arbitrator and the panel of the list, there is a difference. This is the only point of contention I have before my lord today. My lord will in that case take up 64, which the GCC which my lord is looking at, 64(3)(a) Roman 1 would be applicable to me. Even in that case, there is only one sole arbitrator. My lord, the personal, it has been indicated that it has to be a gazetted officer of the railway. If that person will be ineligible, my lord appoints any one sole person as the arbitrator. I have no further arguments to that. And for this, the reason why I am saying ACS, my learned friend has argued that ACS 10 would apply just from the letters, but it will not apply in terms of paragraph 70 of that particular judgment. There are letters that I have issued subsequently that ACS 10 will not apply, because ACS 10 takes me to Council of Arbitrators, which I am not agreeable to their list of engineer panel of ICA. This is my only contention.
Lord, most humbly, I beg to submit before Lordship. This is very unfortunate because till date the stand was it was a waiver, but now it is a new stand from the other side, my lord. My lord will kindly come. My friend has shown you, Lordship, the annexure, the striking out part. My lord kindly comes that annexures are attached with the communication.
He's not arguing that. Now he's arguing ACS 10 or ACS 6.
Oh, my lord, my lord. Just only for your lordship corroboration. Only for lordship corroboration, I am reading out one paragraph only from page 99 of their application, a letter dated demand of arbitration 17th April 2025. My lord may kindly come to page 99 directly of the application. Page 99.
Yes.
Lordship has got the very first paragraph, running page 8 and page 99. It is pertinent to mention here that we do agree to waive off applicability of section 12.5 of arbitration and conciliation amendment, and in this regard we are annexing the prescribed format as given in annexure 15 along with this letter. It was their explicit waiver, my lord. Now, my lord, regarding applicability of ACS 10, my lord may kindly comes to page 42, which is the
Page 42.
clauses of contract. Page 42 of the application, my lord, itself.
Yes.
It starts from page 27. My lord may kindly come to page 42 and clause 30. Lordship has got clause 30. For settlements of disputes, Arbitration and Conciliation Act 1996 and provisions made in relevant clauses of GCC 2022 with up-to-date correction slip will be binding. It was the essence of the contract, my lord. Now, my lord, in terms of this contract, and also, my lord, it was been further corroborated in the contract, page 18 also. Your lordship will find. Page 18, my lord. It is the contract agreement of works. Page 18 of the application itself. Your lordship will find at the second paragraph from the top, whereas the contractor has agreed with the railway for performance of works, provision of cover shed in connection with development of freight maintenance facilities at Adra Yard and Sikh Line for maintenance of BCN and other rakes in Adra Division of Southeastern Railway set forth in the schedule hereto, annexed upon the standard general conditions of contract corrected up to latest correction slips and in specifications of Southeastern Railway corrected up to latest correction slips and the schedules of rates of Southeastern Railway corrected up to latest correction slips and the special conditions and special specifications. So, my lord, from the very beginning, it was very much evident from the contract itself that the GCC and its latest correction slip will be applicable regarding the implementation of the contract, my lord. Now, my lord, kindly comes to page. Now, my lord, kindly comes to page, kindly. Page 102, my lord, of the application. It was a communication dated 23rd April 2025 made to the other side, my lord, from the railways. My lord may kindly come to the last paragraph, the bigger paragraphs, that is starting from copy for information, so and so. My lord may kindly come to the part at the 1, 2, 3, 4, 5th line of the Railway Board vide letter dated so and so policy dated 4th March 2025 has forwarded one correction slip number 10 of Indian Railway Standard General Conditions of Contract April 2022. In correction slip number 10, there is provision of appointment of either railway retired officer or arbitrator from panel of Indian Council of Arbitration ICA. Copy of the correction slip number 10 is enclosed for perusal and detailed information. He is requested to submit in writing his choice of panel. If he chooses the ICA panel, he is requested to nominate at least 2 names from the arbitrators from the ICA panel and send the same to this office with their consent in prescribed form for appointment of one as contractor's nominee. So, my lord, it was amply clear. The process was very clear. And my lord, in terms of this letter, I have shown before your lordship the letter. They have picked up 2 names from the ICA panel and given us for our choices their nominee. Now, my lord, when ACS 10 comes into play, your lordship will again come to the, may again come kindly to the page 98 of the GCC as my learned friend has handed over to your lordship. Clause 64.3 at page 98, my lord, of the GCC, my lord.
Yes.
Lordship has got the clause 64.3, my lord, at page 98 of GCC.
Yes.
It is about the appointment of arbitrator, 64.3a, appointment of arbitrator where applicability of section 12.5 of Arbitration and Conciliation Act has been waived off. My humble submission before Lordship, it is squarely applicable in this case because they have explicitly waived off that provision of 12.5 in terms of their letter as well as annexures. Now, my lord, it is about how to appoint the arbitrators regarding when the claim is above 1 crore and when the claim is not above 1 crore. But my lord, after issuance of ACS 10, the situations comes to the position your lordship will find at a page 105 of the application because the entire thing goes when ACS 10 has been issued. Page 105 of the application, my lord. Lordship, Lordship has seen page 105, my lord. It is regarding clause 64.3a, part 2 GCC. 64.3a was earlier regarding the appointment of arbitrator. Now it comes as 64.3a. The arbitral tribunal shall consist of a panel of 3 arbitrators. General managers, additional general managers will appoint 2 arbitrators, 1 railway nominee and other from among the contractors nominee. Contractor can recommend his nominee either from approved panel of railways or from approved panel of Indian Council of Arbitration within 30 days from the date of dispatch of approval of written and valid acceptance of demand for arbitration by the general manager or additional general manager. So therefore, my lord, the earlier provisions of GCC of clause 64.3a has now been modified as there should be a panel of arbitrators, 1 nominee from the railway, 1 nominee from the other side, and my lord, they both will jointly decide the third arbitrator. So as my lords, it is squarely visible that they have waived off the applicability of section 12.5 of Arbitration Act, and ACS 10 is applicable in terms of the GCC, in terms of the contract. Therefore, my lord, and they have already submitted 2 names. Now they are now, my lord, it is up to your lordship, my lord.
How do you overcome this letter which you have written?
My lord,
Where
the
you have
letter.
accepted.
My lord, I will not come in. I will not try to indicate otherwise. My lord,
How do you overcome this letter, sir? Please.
My lord, on the prior to
Your client is acting smart, nothing else.
My
If
lord,
you have admitted to GCC 10 in your own letter, today how are you saying that GCC 6 should be applicable on you?
this application was pending for a long time. The
It doesn't
main
matter.
facts is
It
was
just doesn't matter, sir,
and
whether
it-
the application is pending for a long time or not. Once you have written a letter, how can you go back on this letter?
my lord, they had written the letter.
File a 340 against him.
My lord,
You have.
this,
Oh, no, this is.
my lord, I'll indicate. My lord, the matter was being taken up. These
This
documents have come forward.
No,
and
sorry, sir. Your client is over smart.
in order to buy peace,
your
this
client is over smart. You're wasting the time of the court. They should be dismissed with cost. This should be dismissed with a heavy cost of 1 lakh rupees.
My lord,
For just wasting the time of this court and taking me around to different provision when you have admitted to GCC 10. I'll dismiss it with cost. You withdraw this petition, I'll dismiss with cost. What do you want? You have wasted enough time. I will not let you go like this.
Because my lord, the
I
judgment.
will not let you
I
go like this, sir. You have written a letter. I will not let you go like this. You either withdraw this petition or I'll impose cost and dismiss this matter.
Because my lord, when the
I am not concerned. You get that?
My lord, I'll take instructions. My lord, on the
Sir,
previous occasion, I had come forward and
I'm
indicated
not
this letter.
concerned.
My lord. My lord, I'll take instructions.
Come back in 5 minutes.
My lord.
Grateful.
Do you think you can take the court for a ride? Smart arguments. I'll impose a cost of 1 lakh rupees.
I'm sorry, my lord.
Wasted my time. When you admit to it, and then I'll come back in 5 minutes. You
My
take
lord,
a call right now.
I will make the call. My lord, the only reason is on the last
Take a
occasion I had
call
indicated
right
this
now.
letter. Very well, I'll do that.
Very short practice.
I've taken instructions, my lord. I'll withdraw the matter.
Waste time of the court.
I'm extremely sorry, my lord.
Learned counsel for the petitioner seeks to withdraw the present petition. The same is dismissed.
Grateful, man.
May I
We
indicate?
we
May I
have
indicate?
faith in lawyers like you, and you waste the time of the court. You almost wasted 1 hour.
I'm sorry, I tender my apology, my lord. And may I indicate one more thing, my lord? My lord also records this letter, the last letter which was issued.
That's your letter. Why
Yes,
should
my
I
lord,
record?
records it. Otherwise, tomorrow again another application. Someone else may come up with another application.
That's why I'm not giving liberty.
Very well. Much obliged.
Grateful, my lord.
Nine.
This is a supply contract to Chittamoranjan Locomotives. My lord, the arbitration clause is not in dispute. Your lordship kindly
Page,
take
sir.
all.
Page.
My lord,
Page.
my lord, the arbitration clause, kindly give me a moment. That's at 115, 115,
Second
clause
one.
2900. This is not that standard railway clause. This is with regarding to supplies to stores. So they have a separate contract with regard to that.
Sorry.
1152900.
115.
In the event of any question, dispute or difference arising under these conditions, and I'll show how this is applicable to me because the tender documents clearly makes this applicable to the contract between the parties.
Yes.
Which is specifically provided for by this, the same shall be referred to the sole arbitration of a gazetted railway officer. Although that cannot be done in view of the larger bench, the general manager in case of
That
contract.
can't be done.
My lord,
That can't be done.
that can't be done. But my lord, I have written my section 21 notice. That's at page 81, annexure C. There's no response to this notice.
Yeah. What is your objection?
Under instructions, this is my instruction. I cannot say this as my objection, but my instruction is that there is a specific method in which the arbitrator is to be appointed, which is not being appointed. Probably I cannot take this objection under because of the 2015 amendment. I cannot, but that is the instruction. My lord will kindly record my objection and it will pass whatever order my lord gives.
My lord, only thing, my lord, I am enjoying an interim order from the commercial court at Asansol. Lord, for a time being, that protection may
I
be.
can't do that. I can do nothing about it. Your section 9 is filed there. I can't extend it. I can't. I can do nothing about your section.
Well, we will.
Just give me the facts. 21 notices 1 for
Yes.
2025.
21. No. My lord, we
This,
were given a notice inviting tender. If your lordship kindly looks at the section 21 notice at page 81.
Yes.
This was a notice inviting tender right in the peak of COVID, 3rd of July 2020, following the Indian Railway Standard conditions of contract, but for delivery of gearbox case. My lord, we had supplied certain items, they cancelled, we asked for reinstatement, they reinstated, again cancelled, and after that the prices had increased so much that it was not possible. And it is actually their claim. They have made a claim of about 2.38 crores. And on the basis of this contract, I execute other contracts for Indian Railways. They are withholding those payments which are receivable under those contracts.
Claim of 2385331.
Yes, ma'am. That is their claim. They are claiming damages. Yes. Yes.
Take down. The present petition has been filed under Section 11 of the Arbitration Conciliation Act 1996, seeking appointment of an arbitrator to adjudicate the dispute between the parties. Full stop. The petitioner is a MSME unit engaged in the business of manufacturing metal and chemical products for a considerable period of time. Full stop. Pursuant to a tender floated by the respondent, the petitioner was declared successful and a purchase order dated 16/11/2020 was issued in favor for supply of gearbox case. Yeah, gearbox for wrap so and so 318 in number. All right. Yeah, full stop. The total value of the total, how much is the total value of this?
My lord, the entire tender?
3369.
Yes, my lord. My lord, kindly gives me a moment. It's not too legible. My copy.
2695480 subject to correction.
लिखा আছে ये तो দেখছি record করে। একটু legible, তোমার কপিটা legible? The first purchase order the rate is given. It is total value is 3269. Your lordship kindly takes page 40.
32695480.
Yes, my lord.
3269.
That was the total value.
The total order value was rupees so and so. The general condition of contract forming part of the said purchase order contained an arbitration clause. Full stop. Owing to practical difficulties, the petitioner could supply only 60 numbers in 8 tranches out of the total requirement of 380 numbers. Full stop. 18. 318. Thereafter, the respondent issued a cancellation advice bearing number 00512 dated 25/3/2022, cancelling 232 numbers and raised a claim of rupees 238,533.12. Pursuant thereto, the petitioner the petitioner made several representation against the said action. Subsequently, the respondent issued a restatement advice bearing number CA 001372 dated 12/7/2022, whereby the purchase order dated 16/11/2020 was reinstated in respect of 232 deliverables. Full stop. Pursuant thereto, the petitioner supplied a further 20 numbers in 5 tranches. Thereafter, by letter dated 2/5/2023, the petitioner expressed its inability to supply the remaining deliverables Full stop. The respondent, however, issued a modification advice number 00522 dated 4/3/2025, permitting the petitioner to supply 28 deliverables over a period of 2 years. Full stop. Subsequently, the respondent issued a cancellation advice bearing number 001775 dated 11/7/2024, cancelling the purchase order in respect of 232 numbers and imposed a demurrage charge amounting to 244,70208. Aggrieved thereby, the aggrieved thereby, the petitioner approached the commercial court at Asansol under Section 9 of the Arbitration and Conciliation Act, seeking interim measures. Full stop. By order dated 12/3/2025, the learned commercial court restrained the respondent from recovering the said amount from other bills of the petitioner pending with Indian Railways. Full stop. Is the interim order continuing?
Yes, my lord, it's still
The
29th
said
of
interim
July.
order continues to remain in force. Full stop. Thereafter, the petitioner invoked the arbitration clause as contained in clause 2900 of the Indian Railway Standard Conditions of Contract by notice dated 1/4/2025. Full stop. Despite receipt of the said notice, the respondent failed to take any steps for constitution of the arbitral tribunal. Full stop. Learned senior counsel for the petitioner, Mr. Rudraman Bhattacharya, submits that the disputes have arisen between the parties in relation to the wrongful cancellation of the purchase order and imposition of demurrage charges, which squarely falls within the ambit of the arbitration clause. Full stop. Learned counsel for the respondent states that the arbitration clause itself has provided a mechanism for the appointment of the arbitrator, and that the present petition is thus not maintainable. Full stop. It is no longer in dispute that the respondent cannot unilaterally appoint an arbitrator unless and until there is an express waiver by the petitioner under Section 12(5) of the Arbitration and Conciliation Act. Full stop. Since the arbitration clause is in contravention to the settled position of law in the case of central electrification citation, so and so, the present petition is maintainable, and this court deems it fit to appoint an arbitrator in terms of the arbitration clause as contained in the agreement, the general clauses of contract. Full stop. Learned counsel for the respondent, though, does not dispute the arbitration clause as contained in the GCC. Full stop. This court has heard the submissions advanced by the learned counsel for the parties and has produced the material placed on record. The existence of an arbitration agreement between the parties is evident from the general conditions of contract forming part of the purchase order. Full stop. The dispute raised are arbitrable in nature. Full stop. In proceedings under Section 11 of the Arbitration and Conciliation Act, the scope of examination of this court is limited to the existence of an arbitration agreement. Full stop. Once the existence of the agreement is established and the disputes have arisen, the parties are to be referred to arbitration. In the facts of the present case, the arbitration agreement is not disputed, and the arbitration agreement as well as the arbitration clause between the parties is not disputed. Thus, therefore, this court is inclined to allow the present petition in view of the same. So and so, give a name.
Mr. Shayan Rai Chaudhary.
Mr. Shayan Rai Chaudhary is appointed as the sole arbitrator to adjudicate the dispute between the parties.
He's a member of the Bar Library Club. He's a member of the
Is he a senior?
He's 22 years.
Just give the details.
Shayan Rai Chaudhary, member of the Bar Library Club.
Member of the Bar Library Club, is appointed as the sole arbitrator to adjudicate the dispute between the parties subject to furnishing disclosure in terms of Section 12 of the Arbitration and Conciliation Act 1996. The learned arbitrator shall fix his remuneration in terms of the fourth schedule of the said act. Full stop.
309.
A copy of this order shall be communicated to the learned arbitrator to
942.
take necessary steps. Arbitrability is open to be deep for the client.
The court of appeal.
Your Lordship.
Item 10, I am appearing. May it please your Lordship.
Yes, readings complete.
Yes, my lord, there was a direction upon us to file the affidavit in opposition, my lord. We have prepared it. I'm
It's a
filing.
matter where the union was to appear.
Yes, they are appearing. Is your affidavit in opposition?
Yes, my lord. I have.
This is your affidavit in
Yes,
opposition.
yes, my lord. My lord. Now the difficulty is, my lord, there was a direction to upon us to reveal the appointment of panel of arbitrators of the Ministry of Defense. My lord, we have submitted in the affidavit, my lord. Now the difficulty is this panel was prepared in February 2022 and it was valid till for 3 years. Now, my lord, at this stage, I do not know whether this panel has been extended or a fresh panel has been.
Who knows?
My lord.
No, let me explain. I'll just clarify, my lords. The arbitration clause between the parties envisages an arbitrator to be appointed by the serving officer, which would fall foul of the Perkins judgment.
Yes.
Therefore, my lords, it is in your lordship's hands to appoint an arbitrator, number one.
Yes.
Number two, my lords, what happened in their reply, what we suggested, because there was a panel of the Ministry of Defense where there are retired arbitrate panel, retired technical officers of the government, including the MES. So that would perhaps be more convenient for the other side. So to put an end to the dispute and to, for early disposal, we suggested that from that panel, 3 or 4 names, we are agreeable. Because it is a panel constituted by them, but it is not binding on us. We chose 4 names. They have come up with a reply saying we have no objection to anyone from that panel except one Mr. Gajiria. So, Mullers, that panel is a reference panel. Whether it's today applicable, not applicable, alive, not alive, is irrelevant, Mullers. They can easily agree to it or your lordships can appoint, Mullers. That panel is available at page 7 of their reply, Mullers.
Where's the contract?
Yes, Mullers. The contract is at Mullers. These general conditions are at page 18. The arbitration clause, if your lordship sees page 12 of my petition, also it is reproduced. Otherwise, your lordship will see page 43.
What was the contract for? For construction?
Well, yes, for constructing certain technical buildings in the Air Force in Bagdogra, my lords. Air Force Station at Bagdogra is for alteration of certain technical buildings. So there is no quarrel on the issue that an arbitrator has to be appointed. They also agree. The question is who, and therefore we said that as a reference point we can take
Where's
this.
the arbitration clause?
Well, page 43.
Clause 70, my lord.
Page 43.
It's for a sole arbitrator.
Yes, no difficulty, that's right. But it was the sole arbitrator to be appointed by the engineer officer, and this has been later amended to mean a serving officer would appoint that. So, my lords, that would fall foul of the Perkins judgment. So, therefore, in section 11 is therefore, my lords, it is entirely in your lordship's hand to appoint an arbitrator. What we had suggested, therefore, was for the ease of the other side itself. We said that there is a panel they made. It's not binding on us, but there are a few names that we can be agreeable to, and we have given those names to the other side The panel, your lordships will find at page 7 of their reply. Page 7 of their reply, my lords. If your lordships may oblige me.
So both of you give a name of the person concerned who we can appoint.
Yes, we have already, they have already said that they have no objection to anyone from this panel. We had given 4 names, my lords. Mr. A.K. Arora, Mr. Satish Chandar, Mr. Saurabh
What is that?
Mathur.
Which page?
Page 7 of the reply.
No, where is your letter giving the names?
No, my lord, this was an oral, my lord, in my orally, my lord, in the rejoinder also we have stated so, my lord. This is their reply. And in the rejoinder we have stated we have agreed to that.
Narrow down on a one person.
Yes,
Yes.
Anyone, we do not have any objection to
well,
that.
serial number 15 I had suggested Mr. Arvind Kumar Arora because we find that he is neutral. Serial number 15, my lords. Serial number 14 also. Serial number 2. And serial number 17, my lords.
They had objection on which one?
They had
Serial number 10, my lord.
Serial number 10, my lord. Mr. General Gajiria. My lord, my request is serial number 15, my lord. Person may be appointed, my lord. We are comfortable. They are also comfortable. Mr. Arvind Kumar Arora. He is for a retired MES technical person, so he would be well aware of the workings of the technical projects also, my lord, technical part of things. I'm sure they can't have any objection.
So with the consent, then I'll appoint.
My lord.
I'm great.
The present petition has been filed under section 11(6) of the Arbitration Conciliation Act, seeking appointment of a sole arbitrator to adjudicate the dispute and differences arising out of the agreement / work order dated 30th August 2013 entered between the parties. Full stop. Where's your section 21 notice?
Yes, bro. The invocation notice is that page 86. And there is a prior one also at page 84, 84 and 86 both.
It's not a section 21 notice 84, sir. Where have you invoked the arbitration clause?
Yes, sir. As per condition 70, you are requested to appoint a sole arbitrator to adjudicate upon the disputes. The second line, please.
Page 86, your lordship.
84 and 86.
Learned counsel for the petitioner submits that in terms of the tender issued on
6th July 2013.
6 July 2013, the petitioner were
The acceptance is of 30 August 2013.
the petitioner were granted the work of construction of technical building PEB bracket में at AFS Bagdogra as detailed in the tender. Full stop. The said work contract was awarded to the petitioner on
My lords, the work order date, my lords, is, I'll just give you notes.
when was it given?
My lord, the acceptance, the conditions of contract are signed on 30 August 2013, my lord.
The petitioner had accepted the said work order on 30th
30 August 2013.
30th August 2013 and a work order was executed between the parties wherein an arbitration clause was provided for. Full stop. Dispute and differences arose between the parties in terms of the said work order, and the petitioner had issued a section 21 notice dated
Dated, my lords, 10th October 2019
10th October 2019
and 21st August 2020.
seeking appointment of an arbitrator in terms of condition 17 of the IAFW 2249.
Yes.
Being part of the contract. Full stop. Learned counsel for the respondent does not dispute the work contract as well as the existence of an arbitration agreement as contained in the condition 70 of the IAWF 2249, which forms part of the work contract. Full stop. The parties consent to the appointment of the arbitrator and have suggested the name of Arvind Kumar Arora, right?
Yes, yes, yes.
Mr. Arvind Kumar Arora, DG Personal MES, as the arbitrator to be appointed to adjudicate.
Retired officer. Retired.
Arvind Kumar Arora, retired कर देना, DG Personal MES, bracket में retired कर देना. Full stop. With the consent of the parties, Mr. So-and-so is appointed as the sole arbitrator to adjudicate the dispute between the parties. The learned arbitrator shall enter reference in due compliance with Section 12 of the Arbitration Conciliation Act. Full stop. He shall be entitled to fix his remuneration in terms of the fourth schedule of the Act. Full stop. All issues related to arbitrability, maintainability, limitation shall remain open to be adjudicated by the learned sole arbitrator. A copy of this order shall be communicated to the learned arbitrator to take necessary steps. Give his phone number. You have his number?
I'll get the. I'll provide the number to the court master.
Give the give the number.
I'll provide.
With the aforesaid direction, the present petition stands disposed.
Grateful, much obliged.
Affidavit of opposition. Let's take him up. Palida. Great.
For the respondent.
Yes, yes,
My lord, this is my affidavit of service.
No, 11.
My lord, initially a notice was issued. My lord, this is a job contract was executed between the DDM Enterprise being the petitioner before your lordship and the BSNL, my lord.
Yes.
For The job contract was instituted, my lord, pertaining to a tender. Subsequent to that, my lord, it was terminated on 25th March 2023. Prior to the validity which was ending on 31st March 2023. Subject to correction, my lord, subsequently, my lord, the bill was raised there, which was not paid, my lord. Certain amount was not paid, and an arbitration. The parties came into a conclusion that they'll enter into an arbitration proceeding. 21 notice was also issued to them. The first 21 notice, which was issued, my lord, on 16th October 2025.
Page.
My lord. Page, my lord, 7.
Where's the arbitration clause?
Arbitration clauses, my lord, shall find it on page number 43.
Yes.
My lord, a fresh notice was also issued by us.
When was the first notice issued?
First notice was issued, my lord, on 16th October 2025.
Page 53.
My lord.
Then?
My lord, subsequent to that, my lord, an arbitration petition was filed before the circuit bench, my lord. However, the quantification of the dues were not clear. That's why it was, my lord, it was dismissed, and that's why a fresh application has been filed. A fresh notice has already been sent, which my lord shall find on page number 80, which is the fresh notice, 18th March. However, prior to that, the BSNL authorities have already issued us a notice indicating the name and contact of the arbitrator. That is on page number 78. They have already issued us a notice, which was on 7th January 2026. They have already intimated the contact details of the arbitrator.
You are agreeable?
My lord?
You agree to the name?
My lord, I have no issue.
Then with the consent, we can appoint this person as the arbitrator. Yes.
My lord, for a moment, kindly see, my lord, admittedly that the first petition was
You are
filed.
admitting to arbitration. You have suggested a name of arbitrator. She has no issues with that. We can appoint the person concerned.
Yes, my lord. My lord, only two submission, my lord. One is, my lord, that the matter was filed before the honorable circuit bench. And the issue is same. Now it is filed before your lordship.
My lord, because
Admittedly, that page
circuit bench-
79. And my lord, kindly come. The claim, my lord, what is stated in the first petition, my lord, that start from page 53. Your lordship, kindly come. The page 55 and onwards.
Yes.
My lord, the enumerated specific instances delayed payment with the dates and amounts. My lord, kindly see that bill dated such and such, a clearing or swearing such and such raised with you on
So these are factual
20
position. Why should I get into the factual position?
2019. No, my lord, what I am submitting. My lord, all the bills either 2019 or 2020.
Very good.
So, my lord, whatever may be the date of 2020, that is in date claim, that is alive claim till, my lord, the December 2023, 3 years.
If he is pursuing it, then it is beyond 3 years also.
So it is only my submission, my.
Yes.
Well,
You can raise this before the arbitrator.
If it is, my lord, the.
Can I decide that?
No, my lord. What I am submitting, if, my lord, from their petition, it is clear that the claim is, my lord, the bad by limitation.
That is for the arbitrator to decide, sir.
My lord, my only submission, kindly record that only two things, nothing more.
Yes, why have you filed it here?
My lord, the matter pertains to the dispute. It was suggested, my lord, verbally therein that this is supposed to be filed before the commercial division of the High Court, the arbitration petition. That's why, my lord, I have approached this bench.
But initially when you had filed it, you had filed what?
I had filed an arbitration petition, but that was before appellate side, my lord, before the circuit bench, because the circuit bench of the High Court does not have a commercial division. Only the principal bench has.
Yeah, now the petitioner has filed the present petition under section 11(6) of the Arbitration and Conciliation Act, seeking appointment of a sole arbitrator to adjudicate the dispute and differences which have arisen between the parties out of and in connection with the job contract dated 1/11/2019. Full stop. It is the case of the petitioner that pursuant to the petitioner being declared the successful bidder, the petitioner had entered into a job contract dated 1/9/2019 for supply of manpower. Full stop. The said contract continued till its termination by the respondent on 25/3/2023. Full stop. The contractual validity being up to 31/3/2023. Full stop. According to the petitioner, under the terms of the agreement, the respondent was obliged to release payment of the bills raised by the petitioner within 1 month from the date of submission thereof. Full stop. However, the respondent allegedly failed and neglected to release the payments within the stipulated period. As a consequence whereof, the petitioner could not make statutory payments towards Provident Fund, ESI, GST, and other statutory dues within time. Full stop. It is contended that coercive actions were initiated by the statutory authorities against the petitioner, leading against the petitioner, leading to substantial financial loss and prejudice to the petitioner. Full stop. Learned counsel for the petitioner has drawn the attention of this court to the arbitration clause as contained in the work contract as clause 15. Full stop. She further states that a notice under section 21 was issued on 16/10/2025 and in furtherance of that, a petition under section 11 was filed before the circuit bench at Jalpaiguri. Full stop. Where's the order? The circuit bench order.
My lord,
It's here,
number
79.
79.
The circuit before the circuit bench as AP number 2 of 2026. Full stop. The circuit bench, by its order dated 13/2/2026, disposed of the said AP number 2 of 2026, granting liberty to the petitioner to withdraw the matter and issue a proper notice invoking arbitration. Full stop. In terms of the said direction, the petitioner issued notice dated 19/3, right?
My lord.
19/3/2025 under section
The fresh notice, my lord, was 18th March 2026, my lord.
It's 18th.
18th, my
March.
lord. 18th March 2026.
Looks like 19th. Page 80.
Page 80, my lord. It's 18th, my lord.
18th March 20. It looks like 19. Are you sure?
My lord, 19. Okay, subject. I apologize.
19th March 2025.
2026.
2026. Under Section 21 of the Arbitration and Conciliation Act. Full stop. Learned counsel for the respondent states that the present petition is not maintainable before this bench since the petitioner had approached the circuit bench at Jalpaiguri by filing an earlier petition under Section 11 of the said Act. Full stop. He further states that the claims filed by the petitioner relate to the period 2019 and thus are barred by limitation. These are the two submissions, 19 and 20, claims related to 19 and 20. Mr. Sen, as far as the commercial division is concerned, this will be the right forum, right? As far as Section 11 is concerned. In view of the disputes having arisen between the parties, the petitioner has invoked the arbitration agreement as contained in clause 15. Full stop. This court has considered the material placed on record and the submissions advanced by the learned counsel for the parties. This court is, since this matter pertains to the commercial dispute between the parties, this court has adequate jurisdiction to entertain the present petition. Full stop. As far as the contention of the respondent regarding the claims are concerned, it's an issue to be decided by the learned arbitrator whether the said claims are maintainable or arbitrable. Full stop. Full stop. In view of the limited scope of examination under Section 11 of the Arbitration and Conciliation Act, this court needs to see the existence of the arbitration agreement and the arbitration clause as contained in the said agreement. Full stop. In the facts of the present case, the parties do not dispute the arbitration agreement as well as the clause as contained in the said agreement. Full stop. Thus, this court is of the view. This court is of the view that this case is a fit case for appointment of an arbitrator. Full stop. Accordingly, so and so is appointed. उससे पहले एक line लिख देना. Learned counsel for the respondent had admitted to the. Where is that letter?
878, my lord.
Had admitted. Had admitted to the appointment of an arbitrator by issuing a letter dated 7/1/2025, wherein they had suggested the name of Shri Sadipta Pandey, Senior Counsel, Calcutta High Court, as an arbitrator to be appointed in terms of the contract. Full stop. उसके बाद कर देना. Accordingly, this court appoints. Should I appoint the same person? Appoints with the consent of the parties. This court appoints Ms. Sudipta so and so as the learned sole arbitrator to adjudicate the dispute with the dispute between the parties. The mobile number is here, page 78 is a mobile number. The learned arbitrator shall enter reference in due compliance with Section 12(5) of the said Act. She shall be entitled to fix a remuneration in terms of the post schedule of the said Act. A copy of this order shall be communicated to the learned sole arbitrator to take necessary steps. Full stop. All issues pertaining to arbitrability, maintainability claim shall be adjudicated by the learned sole arbitrator in accordance with law. Full stop. With the aforesaid direction, the present petition stands.
Very good. My lord, one kind indulgence, the second notice, my lord, perhaps it will be 18th because there is a receiving stamp by the BSNL office.
19th for
That was 19th, my lord, dictated, my lord.
18th.
That shall be 18th March, my lord.
19th लिखा है ना? Notice under 21. 19th. 18th.
18th, my
18th.
lord. Great. Grateful. नाम आता है ওটা হ্যাঁ ফোন নাম্বার আচ্ছা বাবা মানে grateful, my lord.
Yes.
Just
Yes.
find the wakalat
For that, it has come.
The one that was stuck in the customs.
This is the notarial certificate of the United States. State of Illinois department is saying that it has to be apostille.
It has to be.
This is section 14 of the Notaries Act. But with the leave of your lordship, it can be fine. With section 14 of the
It has to be apostille. It has to be apostille.
the reciprocating country.
Still, it has to be apostille. Every document which comes from there, it has to be apostille. That's how even on
Because since it's a reciprocating country,
still it has to be apostille. Mr. Singh.
Hague contention is very clear on this. It has to be
No, it has to be. Even on the other side also, whenever we have filed
that's why I was saying if the lordship gives us the leave, then we can file. Not other.
Get it in the proper form. Get that corrected, Mr. Singh. This will take at least 4 weeks or 6 weeks.
Another difficulty is that they are saying unless it's the government document.
No, that's not right. That's absolutely not correct.
We will.
That's absolutely not correct. This is just like customs. Please, you can get anything apostilled.
Would your lordship in that event, my lord, take my supplementary affidavit on record?
Supplementary affidavit filed by the.
No.
Sir, I had the privilege of working in the United States. So don't give me that.
We'll have it apostilled and then.
Supplementary affidavit filed by the petitioner is taken on record. Learned counsel for the respondent. You are appearing for respondent number?
6.
Respondent number 6. Seeks and is granted time to file his wakalatnama within a period of 6 weeks. Same with learned counsel for the respondent 1 to 5. Seeks and is granted time to file his wakalatnama as well as affidavit of competence within a period of 6 weeks. List after 6 weeks.
Great.
Where do you come up with those arguments? Yep. Mr. Please file the.
My lord, they have cited 9 new decisions. At the time of argument, they cited only 1. Now there are 9 new. My lord, I've dictated it. My lord, I'll just, tomorrow morning we'll file.
Tomorrow, please give it so that I can finish it.
No, certainly, my lord. My lord, it's very unfair though. My lord, nothing argued. And in the notes, my lord, it's extremely, my lord, voluminous 9 decisions.
Nobody is fair to Mr.
Mr. Chaudhary is never fair to me.
So try to do it tomorrow.
I will, my lord, certainly.
Mr. Chairman, item 13.
Please, my lords. Because I'm appearing for the petitioner in this matter. My lord, this is an application filed under Section 11 of the Arbitration and Conciliation Act. My lord, the dispute herein arises out of a memorandum of agreement dated 21st December 2022. My lord, the arbitration
Affidavit of
clause-
service. You have served the other side.
My lord, we have served the other side. On the last occasion, they had written us an email asking us to take an adjournment because they were keeping ill health. Thereafter, my lords, we issued a subsequent email, which also we had produced on the last date, informing them that the matter was listed on 8th of July, whereby they didn't appear. My lords, due to paucity of time on the 8th of July, the matter was merely re-notified to today.
Where's the affidavit of service?
My lords, we had filed it in May itself, my lord. It should be.
Here. This one.
Please, my lord.
Where's the tracking report?
My lords, after this affidavit of service, they had issued us an email which we had produced on 10th June, my lords. It
That's
is not.
right. You have to serve them.
My lords, we have served them. Thus, the email had come.
Where's the affidavit of service, sir? Where's the tracking report?
My lord, actually, there is some issue with the portal, my lords. It's not showing the booking numbers, my lord. Both of our matters, we are facing the same issue. We're trying repeatedly, but the tracking reports are not available online.
Now, put the tracking report with the affidavit of service. The tracking report first is not
My lords, just one humble submission, my lords. We had filed the affidavit. The other side has responded to us on email asking us to take
Where is
time. My lords, we'll just produce a copy of that. We had produced it on the last date. We'll produce it again.
You can't produce it like this, sir. You can't just hand over a copy of the email like this.
My lords, they had written to us one day before the hearing, my lord. Therefore, we didn't have time. And only to accommodate their request, we had produced that email. Otherwise, my lord, we could have proceeded with the matter.
Not proceeded at all. I will not consider this to be service. Where's the tracking report? How do I prove the service has been
My
done?
lord, this is the letter that we had received on
They
the
might
last
have
date of-
written a letter to you.
An email, my lords. It's not a
They
letter.
might have
yes.
written a letter, email to you. File a service report. Learned counsel for the petitioner. Affidavit of service does not contain the delivery effected upon the respondent. So, learned counsel for the petitioner states that he has received an email from the respondent seeking adjournment of the matter. So, be that it may, let an affidavit of service be filed on the next date. Within 2 weeks, affidavit of service within 2 weeks,
My lord, a fixed date may be given, my lord.
just after 3 weeks.
My lords, may I request for a fixed date since I have to travel
After
from
3
out.
weeks.
Please, grateful.
14.
You have to travel from where?
Bangalore, my lords.
You can do it online.
Please.
At least file the affidavit of service, sir. You have
My
to
lord,
put
there
the
was some
tracking report.
confusion. Actually, they had responded and there was no direction on the last date, but we'll file it up before the next date.
Affidavit of service without a tracking report. How
Please,
do
please,
we assume
please,
it?
please, 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 my lord. We'll file it well before the next date.
ये ठीक है हो गया हाँ क्या मॉडल उसका एफिडेविट सर्विस विदाउट ट्रैकिंग रिपोर्ट आता है
Yes.
Grateful.
Item 15.
For the petitioner, Malat, this is an arbitration, Malat, for appointment of an arbitrator, Malat. Malat, we have sought for appointment under the Malat Credit Information Companies Regulation Act, Malat. Malat, this is the Civil Act, Malat, if your lordship kindly considers. And if your lordship kindly takes, Malat, and what had happened, I'll just give a short background and then I'll. Well, my client, Malat, had sanctions from the sanctions as in Malat, loan sanction from Axis Bank as well as LIC Housing Finance, Malat. So, Malat, CIBIL keeps the records. Now, Malat, the records of the CIBIL
obviously promotes my credit rating or it degrades my credit rating. Now, I suddenly find one fine morning my credit rating has gone up to 9.
9 from 3.
Which is bad. Lower it is better. So from 3 to, it was 3, it went up to 9. So when I start initiating communications with them, for which my loan sanctions all came to a standstill. I am working, as a matter of fact, in the construction business. There were several works continuing where everything stopped. Subsequently, CIBIL said that they had done or downgraded me on the basis of the reports of Axis and LIC. Now, subsequently, when we come across Axis and LIC, Axis says that we had a problem with the name. It was the same name, but the wrong identity. Therefore, we gave a wrong credit rating and that was uploaded. And recently, LIC also said that in LIC's case, they had closed the loan, but it kept on being shown on the CIBIL report.
During COVID, vehicles.
So, this was the dispute. Since there is a dispute, I wrote to under section 18 of the under section 18, if you lodge any fines. Excuse me.
Of the Credit Information Companies Act.
Yes.
Regulation.
There is a provision of settlement of dispute. It's a dispute amongst the credit information company, which is CIBIL, credit institutions, borrowers and clients. So, borrowers and clients involves the banks. On matters related to business of credit information of which no remedy has been provided under this Act, such dispute shall be settled by conciliation or arbitration as provided in the Arbitration Conciliation Act. As if the parties to a dispute have consented in writing for determination of dispute by conciliation or arbitration, and provisions of this Act shall apply accordingly. And where a dispute has been referred to arbitration under subsection 1, the same shall be settled or decided by the arbitrator to be appointed by the Reserve Bank. So, I write to the Reserve Bank. As usual, there is no reply from the Reserve Bank of India. This.
Page 201.
Yes, page 201, your Lordship will kindly find my letter in the nature of section 21 and for appointment of the arbitrator to the Reserve Bank of India, with copies to Axis Bank as well as LIC. Now, my case is that I have suffered damages due to the inaction on the part of both the clients as well as CIBIL.
Page?
Page 201. This is 10th of December 2025. And I will kindly see the subject. Notice under section 21, read with section 18.
Yes.
And it's a big longish letter because obviously the disputes have been mentioned, and at the very end, if you Lordship kindly find that page 200, and paragraph 21 at page 211, I have invoked section 18(2),
Page
211, at the bottom of that page, penultimate paragraph, 21.
Yes.
And the track report, if your Lordship kindly see, it's at page 213, shows delivered.
Yes.
So, therefore, I have come before your Lordship, for appointment of an arbitrator.
Yes, madam. You're opposing?
There is no contract between CIBIL and the petitioner. The petitioner is claiming through section 18, madam. However, for appointment under this statutory arbitration, madam, you have to satisfy that there is a dispute vis-a-vis CIBIL money. If I place the Axis Bank's letter, madam, there it is evident that he has a dispute, Axis Bank has not given any information to CIBIL with regard to that. He has nothing, no dispute, the account, the grading which has been done by CIBIL is correct, or it has to be updated. CIBIL Act of 21 provides a matter. CIBIL cannot to alter or make any modification in the status of it. Has to act. It is only a repository of the information provided by the institutions. The petitioner could have any grievance with CIBIL if the borrower's members institution has given correct information to CIBIL. However, CIBIL has failed to update those information. So there is no such case, So as such, if there is no direct contract between CIBIL and the petitioner, Section 11, I respectfully submit that it does not come into force.
Let us read 18.
Section 18, it can be done if there is a dispute.
So that's exactly what he's claiming.
That's through Reserve Bank of India and in clear case where the dispute is only with CIBIL. Here it's not. The information whatever has been uploaded in the website is as per the information given by the institution, member institution. It's not that CIBIL has committed any error or has failed to discharge its duty as envisaged under the Act.
Under 18, they will fall. If you read 18, just read 18 again.
Any law amongst state information companies, state institutions, borrowers, and clients on the matters relating to business of the credit.
And clients on matters related to business of credit information. You are in the business of credit information. He is a client. You are maintaining his business.
So my client is
Your client can be. Client is not limited to the word client in terms of your bank institution. Those are different. Information, credit institution, borrowers, and clients.
Well, she's for the credit information company.
That's what I'm
So that's
saying.
number one
That's
in
right.
that list. Well,
Yes, the member
So-
institutions are.
So they fall in this category.
I'm not disputing on that matter. That Section 18 cannot be invoked.
All right.
But
Then-
my respectful submission is that Section 18 can be invoked only if we have a direct dispute with civil matters. Had it been case of the petitioner, that
No, that is
despite-
not how it reads.
Despite giving correct
It doesn't read
information-
that way, madam. It doesn't read the section. Read the section. It doesn't read that way.
If kindly take up.
According to you, which category is he?
Kindly take up Section 21 also, madam. Or 21 provides the matter. Had it been case, my lord, then in every case, the party would ask for alteration, and in the moment they will refuse to give alteration, the Section 18 would be invoked. Because I don't have any authority. It is prior to invocation of this Section 18, they have to satisfy that it is only fault on the part of civil matter.
5th July, 5th July 2020.
Has not acted in a manner, which it is required. Kindly come to Section 21, the proviso.
Yes.
Any person who applies for grant or sanction
You are relying on the provided that the credit information company and the specific user shall make the correction, deletion, or addition in the credit information only after such correction, deletion, or addition has been certified as correct by the credit institution, right?
Yes, Bharat. And the next proviso provided further that no such correction, deletion, or addition shall be made in the credit information if any such correction, deletion, or addition is pending for any arbitral tribunal. And so I don't have
This will not apply.
I cannot do any correction. Now, in order to invoke Section 18, they have to first satisfy that the member institution has given correct information. However, civil has failed to upload such information or has downgraded their ratings. But it is not so case. If I place Section 20, Axis Bank's reply in this matter, it appears at page 217. The relevant para is at page 219, paragraph 4. regard to allegation made in paragraph 9 to 14 of the notice, it is denied that my client should have made rectification to the credit profile of your client as alleged by you, and the drawing power of your client would only be fixed after rectification of the CMR rating by relevant authorities. So this Axis Bank is not disputing that the information which is uploaded in the civil website, my lord, that is incorrect, not as per their information provided by. So there cannot be a direct dispute with civil and the petitioner, my lord. It is through the member institutions only. He has separate issue with member institution and civil. If the member institution has given correct information and civil has failed to upload, then this 18 could have been enforced. And that Reserve Bank of India has authority to appoint an arbitrator that it can be. But here it is not such case. He may have may seek appointment of arbitrator in respect of Axis Bank and the other member institutions under this application.
Who appears for RBI? Who's appearing for RBI?
And RBI has not been made a party, because they are the appointing authority, So,
they are made a
pro forma, sorry, pro forma.
They are a performer party.
Pro forma, sorry. But they are really not necessary because they are the appointing authority. I have to only show that they have not appointed.
Not to others.
Let them file the reply then. If they are contesting it, let them file
They want to file a reply.
The petitioner has filed the present petition under section 11(6) of the Arbitration and Conciliation Act, read with Section 18 of the Credit Information Companies Regulation Act 2005 for seeking appointment of an arbitrator for adjudication of the dispute arising out of the alleged erroneous credit information. Credit reporting in the commercial credit information reports pertaining to the petitioner. Full stop. Learned counsel for the petitioner submits that the dispute have arisen between the parties in relation to the reporting and dissemination of credit information concerning the petitioner, and that despite invocation of the statutory arbitration mechanism contemplated in section 18 of the Credit Information Companies Regulation Act 2005, read with the Arbitration Conciliation Act 1996, the arbitral tribunal could not be constituted. Full stop. Learned counsel appearing for respondent number
1.
Respondent number 1 seeks and is granted time to file affidavit in opposition. How much time? 2 weeks?
4 weeks, because they are based in Mumbai, my lord.
4 weeks time to file her affidavit in opposition. A reply to the same, if any, within 1 week thereafter. List after. File it in 3 weeks so that we can finish it off.
Try to expedite because they don't have any office at Kolkata, so it's very difficult to.
All right, 4 weeks, 1 week. And you appear for? Respondent number 2 is Axis Bank. Same. 4 weeks for respondent number 2. Who's for LIC?
FDO service on record?
None appears for the respondent number 3, though they are directed to file their affidavit in opposition. Despite service, none appears for respondent number 3, though they are directed to file their affidavit in opposition within 4 weeks. Reply, if any, within 1 week thereafter. List after 6 weeks.
Also, inform LIC, let me send a copy of the order.
Send the copy. List after 5 weeks.
Very grateful, but has granted me liberty to file it.
After 6 weeks. 1 week.
1 week for reply. Very grateful,
After 6 weeks.
Very grateful.
But interesting. Is there any judgment on this?
Sorry, Malit?
Is there any judgment? whereby
No, my lord, I will point it out, my lord, what she is saying, my lord, because what she said, she does not deny the.
no, prima facie, I'm of the view that
Yes, because the agreement is not disputed. Now, whether I can make a claim against her or not, that goes with the arbitrator. And whether there is a live claim or not, my lord, that again, my lord, because it's a dispute which has arisen, I can make a claim. They can have a, my lord, they can always have a defense.
something similar to that section 14 of the Securitization Act, whereby any dispute between the
Yes, my lord.
lending banks can be referred to.
Can be referred, yes, my lord.
So you can draw perimeteria from there.
Yes, my lord. So it is there.
This says that this has to be done through RBI.
I'm doing it through RBI.
No. That is the second limb of it, madam. If you are saying that has to be done through RBI, then you are admitting to the fact that it can be, it is something which can
Arbitrable.
be arbitrable.
That's what I was on.
If the dispute is particularly with civil itself.
So that cannot be the section 11 quotes with humility, I say. my lord.
You're saying two things at the same time. See, one, you are saying if the dispute is with CIBIL, then the RBI will appoint.
Yes, ma'am.
Right?
Yes, ma'am.
But here, that is the second limb of it. We have to see whether the dispute is arbitrable with you or not. For that, what do you have to say? That argument you can't take. That RBI has to do it. That's
No, my lord, particularly what I.
and you can only say that there's no privity of contract.
Yes, my lord, I repeat myself, my lord, that only in case if they can prove that there is any fault, then only section 18 apply. Otherwise,
No, that is on the merit of the matter.
That's on the arbitrator.
Madam, that the moment you say whether any fault lies or not, that is something which is arbitrable. That is something which the arbitrator will see. All we need to examine is whether this is something akin to section 11 or not.
But with humility,
And something which is just like in section 14 of the Securitization
with humility,
Act.
my lord, may I say this, my lord? The privity of contract, my lord, point does not stand because it's a statutory contract now. And my lord, if the appointing authority under 11.5 is not appointing, I come in. That is what
right to that extent. Then there's no question of any contract also because he derives his power out of section 18.
But my lord, she has a right of filing affidavit, therefore I could not oppose, my lord.
If you would have got a judgment, I would have passed an order.
No, my lord, my lord, this is not on this point, not on the credit
I have
rating.
not really come across anything, but I have to give an interpretation.
My lord,
If I give an
my lord,
interpretation,
let us come back after 6 weeks, my lord. It will
I
be
need a
nice.
reply for that. If I have to give an interpretation.
No, definitely, definitely. That's why I did not oppose, my lord. Very grateful.
This is my application. Day before yesterday, my lord, I had appeared. The affidavit of service was not ready.
Yes.
May I file it now, my lord? My lord, what has happened in this matter, my lord? We have attempted service. Repeatedly, he has received it by way of email. If your lordship takes the affidavit of service first, if your lordship comes to page 4, my lord.
You're serving in by email.
No, we have also served it by courier.
Yes,
We have
where
also,
is that?
yes.
Where's the tracking report?
Yes, my lordship, can you take page 11 first, my lord? That's the Blue Dart service by Blue Dart Courier. The track report, my lord, is on the very next page, page 12. 3 attempts were made, my lord. If your lordship comes towards the middle of the page,
Yes.
on 30th of June 2026 at 15:57, consignee refused to accept.
Where is that?
Page 12, my lord. It's the first, second, third, fourth from the top, my lord. And this has been sent by Blue Dart DHL, my lord, which is a recognized courier service. He has refused to accept it. But interestingly, what is happening is every time we correspond with him on the email, he responds. Every time he wants to make a claim against us, he responds on the email. The moment we send him the application by email, he just keeps quiet. So we eventually decided to send it in by the recognized courier, and this is the track report on page 12. The other track report, my lord, has not been updated, so I'm not relying on that at the moment.
All right, take that. All right, this is service. Now show me the,
Yes, my lord.
wait.
Yes. Your
Show
Lordship
me
will-
the agreement.
Yes, Your Lordship will take the contract itself, which is on starting on page 24, my lord. This is a contract for the construction of a G+3 warehouse for a value of 10.72 crores. Page 24, it starts. 17th of May 2022. KD Enterprises. Civil and structural work. My lord. The contract starts from there. The arbitration clause, my lord, is on page 61. 61. It's an extensive contract which lays out the obligations and duties and responsibilities. And he has been given time schedule and within which he has to complete it.
Arbitration.
Page 61, my lord, at the bottom, clause 73. May I read, my lord? Clause B, my lord, is what we are really concerned with. In the event of the failure of the parties to resolve the dispute in the manner set out above, within 30 days from the date on which the dispute arose, the dispute shall be referred to arbitration. Both parties shall mutually appoint an arbitrator. Seat of arbitration shall be Kolkata. Proceedings under Arbitration Act. Your Lordship turns the page. On the next page, my lord, clause D, subject to the above, the courts in Kolkata. My lord, here is a typographical error which I need to point out to your Lordship. In brackets, it has been mentioned Maharashtra state. Kolkata is actually not in Maharashtra state. So this is a typographical error which I need to point out, my lord. And shall have exclusive jurisdiction to hear the matter, my lord.
Section 21 notice.
Yes, my lord. Section 21 notice is on page 106, my lord.
The contract was terminated.
I'm sorry, my lord.
Was the contract terminated?
Yes, my lord. It was terminated. The
Page?
termination letter is on page 82. And he responded to this. When I sent him this by email, he responded to this termination letter. 82 is my termination, my lord. It was served to him also by email, not only exclusively by email. It was also sent to him by speed post. It came back. He responds on page 89. And he responds on the email. He responds to me as the advocate on record. So when it suits him, my lord, he responds to the emails. When it does not suit him, he does not respond to the emails. The section 21 notice, my lord, is on page 106. Again, we sent it to him by email as well as speed post. This he has refused also. We also sent it to him by courier. This also he refused. We suggested the name of the arbitrator. If your lordship kindly takes page 111, the last paragraph. You know. The name of the arbitrator we suggested, and we also sought his consent to that. We set out the entire disputes, how it is progressed from the time of the contract being issued, and we finally issued this notice to him. Kindly take 115, my lord, which is the refusal of the section 21 notice also. Kindly come to the middle of the page on 7th of April 2026, your lordship got. Consignee refused to accept. Now, my lord, this is despite the fact that in his GST returns, he is still showing that address. He has not changed the address, nor has he intimated to me that he has changed the address. He is still filing his returns from that very same address. But he chooses to remain quiet and avoid service this way.
Take down affidavit of service taken on record. The affidavit, the report indicates that the respondent has refused service. Refusal of service is good service. So despite service, none appears for the respondent. Full stop. The petitioner has filed the present petition under Section 11(6) of the Arbitration Conciliation Act, seeking appointment of an arbitrator in respect of the dispute arising out of the work contract number ये यहाँ से लो WO Calcutta 2021 ये number 24 dated 17/5/2022. Learned counsel appearing for the petition submits that the arbitration agreement contained in clause 73 of the contract was invoked by issuing a notice dated 17/3/2026. It is submitted that the said notice was served upon the respondent through DHL, right? DHL.
I'm sorry, Miller. It is now known as Blue Dart DHL.
Through Blue Dart DHL. The said service was refused by the respondent. Refusal of service will be assumed to be good service. Thus, the Section 21 notice was duly served upon the respondent. The show me that 21.
Yes, Lord. It is on page 106, Miller.
No, the service.
Service is on page a little later, Miller. Kindly give me a moment. 115, Miller. I'm sorry, Miller. Your Lordship is asking for service of the Section 21 notice.
It's not been served, sir.
No, Section 21 notice, Miller.
Yes, sir. Yes.
Yes, on 115, Miller.
No, sir. 113. Come to
No,
113.
that is one of that is the speed post, Miller. What I'm showing your Lordship is the courier service, Miller, 115.
You have to do it. Courier service, I will not accept.
Miller, he is
That too, addressee left without instruction.
no, Miller, what is happening is he is deliberately avoiding the Section 21. He's not receiving it. He is not just not accepting it. We have sent it to him even by email. He has received it by email. There's no response from him on the email.
No, sir, you have to serve him again. I
But
will
the-
not accept this. Private service, I will not accept. This is
Miller,
Rahul.
I had mentioned on the last occasion that he is avoiding service. Kindly let me serve it by courier.
Sir, you have to serve Section 21 notice. I will not assume this to be service of 21 notice.
No, but Section 21 notice, Miller, also I have served.
Addressee has left. Sorry, sir. The report indicates that the addressee has left on page 113.
Miller, may I indicate what is happening is?
Whatever
is-
has happened, service has to be done, sir.
Miller, it has been done
I-
by the courier service, Miller, on page 115.
Sir, this private courier service,
It's not a private, Miller, it is a recognized courier service.
I will not accept it. This is addressee left as far as the speed post is concerned. I will not accept this as a service. Even the other report which is there of the Department of Post, addressee left without instruction.
Miller, but then that controverts, or rather, it contradicts actually what has actually happened on 115. That's all I'm saying. Miller, he is there.
If you want a finding, I'll give you a finding.
No, Miller, what
At
is
this stage, this court is take down. The report indicates Section 21 जहाँ लिखा है वो उसको काटो last line को उसमें लिखो. The report indicates that the addressee has left and thus the service could not be affected. Full stop. At this stage, this court is not inclined to proceed further on the basis of the material placed before this court. The service of notice invoking Section 21 of the Arbitration and Conciliation Act cannot be said to be free from doubt. Full stop. While one mode of service indicates refusal, another mode of service suggests that the addressee has left the address. In the absence of clearer material, this court considers it appropriate that the respondent be afforded an opportunity to serve upon the respondent. Full stop. Accordingly, the petitioner is granted leave to effect service upon the respondent The present petition is dismissed at this stage, with liberty to the petitioner to file appropriate proceedings in accordance with law.
My lord, subject to your lordship's leave, may I do so by having a substituted service, my lord? If your lordship can do that, I
Sir,
can do so.
21 service, you try to serve them, we'll see that.
My lord, he's
21, I can't do a substituted service.
No, he's
11 I
my
can
lord.
still
Well,
do it.
all I'm saying is subject, of course, to what your lordship may say.
Get the address, sir. Try to do it whichever way you want to. I'm not here to serve. Next.
Seventy.
Lordship, I appear for the petitioner, Lordship.
Yes.
We are not disputing the arbitration clause. The lordship may appoint any arbitrator in the lordship's reserve.
Lord-
We have disputes arise out of a development agreement. But if my learned friend is agreeable, my lord, we can agree on it, or your lordship may.
Lordship, there's a sole named arbitrator in the agreement. He's disqualified under schedule 5th.
Obviously, the sole name arbitrator, you forget about it.
Lordship.
Now tell me, do you consent to some name?
Lordship, we have a suggestion in mind, Lordship. Former Chief Justice of this court, Jyotimay Bhattacharya, Lordship.
What is the contract?
Development agreement, Lordship. That is at
Where is your 20? Give
my
me the-
21 is at page 236, Lordship, and their reply is at page
Wait a
250.
minute. Development agreement dated
27th March 2017. The arbitration clause is at page 68.
page
68. Article 22, Lordship.
Where's the 21 notice?
Lordship, it's at volume 2, page 236.
Entire dispute is there.
Lordship. Page 239 had also suggested the name of the arbitrator and asked for their consent, but they had refused to do so
Client is
at
an
page
employee.
250.
State development agreement. Under the CC development agreement. Take on the
Your lordship may also take note of clause 11.2. But somehow there are two arbitration clauses, but that should not skip the clause 11.2. But same.
as a named arbitrator.
Yes, Lord, even in Lord, the clause which your lordship has seen before, Lord, named arbitrator. Lord, since there are two clauses, Lord, that should not skip.
Which page is that? 21 notice.
Page 236, Lordship.
The petitioner preferred the present petition under section 11(6) of the Arbitration Conciliation Act, seeking appointment of an independent and impartial sole arbitrator to adjudicate the dispute between the parties that have arisen out of and in regard to the registered development agreement dated 27th March 2017. Full stop. Our client is learned counsel for the petitioner submits that the petitioner was involved in the infrastructure development and had entered into the development agreement dated 27/3/2017 with respect to the development of an immovable property being premises number 3 and 4 Mahinder Roy Lane, PS Topia, Calcutta. Was 236. He further states that in pursuant to the said agreement, his client had invested and incurred expenses to the tune of 10 crore 70 lakhs for the development of the said property, right?
Lordship.
He further states that he had received a termination letter dated 7/12/2025, wherein the respondent had terminated the said development agreement and had forfeited the refundable deposit amount of 10 crores 70 lakhs. Full stop. He further states that he had incurred additional expenses by engaging several architects and consultants for preparation of the development scheme, securing amalgamation of the land parcel before the Calcutta Municipal Corporation, and had been paying municipal taxes till September 2025, and had further taken effective steps for resolution of various litigation concerning the title of the property. The dispute and differences arose when the respondent terminated the development agreement and forfeited the security deposit of 10 crore 70 lakhs, alleging that the petitioner had failed to obtain the requisite ULCRA clearance within the stipulated time period of 90 days from the execution of the agreement. The petitioner contends that the said termination is illegal and contrary to the terms of the agreement. It is further contended by the petitioner that time was not of essence in the contract and the stipulation stood waived by the conduct of the party, and the requisite clearance had in fact been obtained in the year 2019 with the knowledge of the respondent, and that there was no contractual provision authorizing forfeiture of the security deposit. Learned counsel for the petitioner further states that he had issued a Section 21 notice on
7th
7th May 2026 in terms of Article 22.1 of the Development Agreement dated 27/3/2017. Full stop. He further states that he had filed a Section 9 also.
Yes, Lordship, I had filed a Section 9. I have secured an interim order.
He had filed a Section 9 petition. Where's that page?
Lordship, my order is at page 223.
He had filed a Section 9 petition wherein he had secured some interim orders. Full stop. Learned counsel for the respondent states that he does not dispute the development agreement, neither does he dispute the arbitration clause as contained in the said agreement. He states that he is to adjudicate the dispute between the parties. Full stop. With the consent of the parties, this court appoints Justice Jyotirmay Bhattacharya, retired, as the learned sole arbitrator to adjudicate the dispute between the parties. Full stop. The learned arbitrator shall enter reference in compliance of section 12(5) of the said act. He shall be entitled to fix his remuneration in terms of the first schedule of the act or with the consent of the parties. Full stop. A copy of this order shall be communicated to the learned arbitrator for taking necessary steps with the all issues pertaining to arbitrability, maintainability, limitation shall be left open to the learned arbitrator to be adjudicated upon. With the aforesaid direction, the present petition stands disposed of.
My affidavit of service.
Affidavit of service taken.
Obliged, Lordship.
Number then. Give the number. Phone number you have?
I'll just send it from.
Just give it to the court counsel. Respondents. Respondents. Respondents.
From
Let's take them.
My lord, I appear for the respondent.
Yes.
May it please the lordships. My lord, it was a coal mining project. My lord, the job was for, my lord, extraction of coal,
Yes.
transportation, and, my lord, OB handling. Now, my lord, the disputes arose between the parties.
My lord, before my learned friend starts, my lord, I am not opposing to this application, my lord. My instructions are not to oppose. So, my lord, your lordship, my lord, may appoint, my lord, any, my lord, impartial person as an arbitrator, your lordship. Anyone.
Suggest a name.
My lord, kindly, my lord, takes up, my lord,
Just give me the details.
yes, my lord, arbitration agreement.
Yes, page
160. My lord, kindly turns to page 163, volume 2. In my lord's brief, my lord will find it, volume.
I'll get all the details from your 21 notice. Give me the 21 notice.
Correct.
387.
My lord, 387.
Third volume.
My lord, third volume, page number 387.
Annexure double N.
And what is not there,
yes,
my lord, the section 9 proceeding, the last order, my lord may also have a look into. My lord, I filed a section 9 is a subsisting injunction order against their invocation of bank guarantee, where they filed, my lord, an application for extension of bank guarantee, where, my lord, this last order was passed, dated June 24. Lordship will find, my lord, every details from there also, which also recorded note of this present proceeding before your lordship. And the interim order has been extended, my lord, till, my lord, July 28.
This is more to do with the bank guarantee.
Yes. Now, my lord, kindly turns to my section 21. It starts from page 387. The disputes, my lord, that lordship will please to find.
Your agreement is 12/11/2022.
Correct, my lord.
Right?
Correct, correct. Absolutely correct. My lord, LOA on 27/5/2022, work order on 19/10/2022, agreement, my lord, 12/11/2022, and the alleged, my lord, notice of termination on 31/12/2022. 25, my lord, I stand corrected.
31/12/2022.
My lord. Now, my lord, your lordship would be pleased to find, my lord, such facts at page 390, my lord, paragraph 16 onwards. My lord, what are the disputes essentially, my lord? In para 16, my lord, I have summed up.
to some extent, my lord, the other part, my lord, which I have also, my lord, recorded at paragraph 22 and 23 in the next page. My lord, the machineries details, my lord, which are indicated at para 23 are still, my lord, withheld by them. My payments to the last running bills, bank guarantee, my lord, the dues on account of, my lord, retention money, nothing have been paid. So they have also agreed, my lord, there are disputes. And my lord, the summary of the quantification that my lord will be pleased to find at paragraph 32 at page 393. Lordship has got, my lord?
393.
393, paragraph 32. A sum of rupees, my lord, more than 4 CR as tentatively, my lord.
All right. Take. This is an application filed under Section 11(6) of the Arbitration Conciliation Act seeking appointment of an arbitrator, sole arbitrator for adjudication of the dispute that has arisen between the parties under a contract agreement dated 12/11/2022. Full stop. The petitioner is the sole proprietor of Hindustan Construction and MSME contractor, while the respondent is the Eastern Coalfield Limited, a subsidiary of Coal India Limited. Full stop. The respondent floated a notice inviting tender dated 11/11/2021 for the work of hiring of HEMM for extraction and transportation of 4.11 LTE of coal. Yes. Floated for work of hiring of extraction transportation. यहाँ तक श्रीपुर एरिया वहां तक डालो. उसके बाद the petitioner was declared successful in the tender process and a letter was issued on. When were you given the contract? May.
My lord, this May, my lord. At page 388, your lordship will find all the details. My lord, LOA was issued on 27th May 2022.
27th May 2022.
Lordship. Then work order on
and
19th
work
October.
order number, यहाँ से उठाना.
My lord.
Work order
Please,
number so dated 19/10/2022 was issued in favor of the petitioner.
Please, my lord.
Pursuant thereto, the parties had entered into a contract dated 12/11/2022 valued at 158585822.31. Full stop. The petitioner furnished a performance bank guarantee for a sum of rupees 1585859. Full stop. The agreement contains an arbitration clause under Article 14 of the General Terms and Conditions.
Page 163.
Full stop. According to learned senior counsel for the petitioner, submits a serious dispute arose during the execution of the contract. It is alleged that the respondent failed to hand over hindrance-free and contiguous project land within time, resulting in substantial delay in execution of the work. Full stop. The petitioner further contends that there has been a persistent mismatch between the quantity of coal reflected in the challans issued at the SSI open cast patch depot and the railway receipt generated at the Sadgram railway siding, resulting in an alleged shortfall of about 12849 metric tons of coal. He further contends that repeated requests for joint inspection and measurement were allegedly ignored by the respondent. The petitioner further alleges that the respondent unilaterally imposed electricity charges on the petitioner at the rate of rupees 112 per unit, whereas similarly situated contractors were charged rupees 11.71 per unit, and that the arbitrary deductions were made from the running account bills of the petitioner. Full stop. It is further held that the petitioner was compelled to consent to sale of coal through e-auction by road to the extent of 50% of the production. Full stop. Disputes have also arisen regarding penalties imposed on the petitioner for alleged shortfall in coal production, despite the respondent's own hindrances. Full stop. Petitioner submits that the respondent issued 2 show cause notices in May 2025, followed by a notice of personal hearing, though no final decision was taken on the representation of the petitioner. Thereafter, the respondent issued a termination notice dated 31/12/2025, giving retrospective effect to the termination from 18/7/2025 for the alleged breach of contract and threatened debarment and other penal consequences. Full stop. Learned counsel for the petitioner states that the respondent had that the respondent, despite their own hindrances, had alleged the breach upon the petitioner for the non-performance of the contract. He further states that he had approached this is which court?
Asansol Commercial Court.
Asansol Commercial Court.
My lord.
Under Section 9 by filing a mis-arbitration case commercial 03 of 2026, wherein he had obtained a favorable order staying the bank guarantee to be encashed. That's the order, right?
Yes.
Full stop. Learned counsel for the respondent does not oppose the execution of the agreement between the parties, neither opposes the arbitration clause as contained in the said agreement. Full stop. He consents to the appointment of the arbitrator in terms of the said contract executed between the parties. Full stop. In view of the same, this court appoints
Any former judge,
you tell me?
Or former justice, Chief Justice. Justice Mukherjee or Justice Bhattacharya or
Justice
Justice
I.P. Mukherjee
My lord.
as the learned sole arbitrator. I.P. Mukherjee retired as the learned sole arbitrator to adjudicate the dispute between the parties. Full stop. The learned arbitrator shall enter reference in due compliance of Section 12(5) of the Act. The learned arbitrator shall be entitled to fix his remuneration in terms of the 4th schedule of the Act or with the consent of the parties. Full stop. A copy of this order shall be communicated to the learned sole arbitrator to take effective steps. All issues pertaining to arbitrability, maintainability, so and so shall remain open to be adjudicated by the arbitrator.
My lord, only one thing, my lord, the contentions, my lord, only one thing, the contentions as raised by my learned senior
That's
friend,
why
my
I
lord,
said
I'm
all the
yes,
points
yes.
are
Kept open.
Yes, your
My
lordship.
said so. Well, explicitly said.
arbitrability, maintainability, limitation,
Yes.
claims, everything
Yes.
open to the arbitrator to be adjudicated.
My lord has been
Deeply
very
obliged.
candidly, my lord, and explicitly said so everything. My lord, one request, if my lords may kindly look into this order passed by Section 9 court.
Yes.
Well, just the last portion. My lord, insofar as the order of this court, my lord,
I can't do anything with this.
I understand. Well, if my lord, my
Even if
adversary
even
my lord says so, my lord,
if he says so, I will not touch.
very,
In section 11, I will not.
Of course,
touch
of course.
I will not say any such things, my lord.
I will not touch it.
Deeply obliged, your lordship.
This is literally intruding in the
Lordship.
section 9 petition.
Lordship.
Can't do that.
But I should not also trouble. Extremely great. Deeply obliged.
Deeply obliged.
This is section 11 application, Lordship. The respondents entered into a development agreement with the landlords.
Yes.
They're short of funds, and my lord, I enter into the picture. There's a joint venture agreement. I have invested 35 lakhs and odd. Now, my lord, there is an agreement that for the net profit, 65% of the share I will receive. Now, my lord, now we have got information that 2 flats already, my lord, erected. My lord, I have not received. I made a legal notice that please give me my money back. My lord, they have not replied. I invoke section 21.
Disputing.
It's premature.
Premature,
Otherwise, my lord, only one difficulty, my lord, in page 51.
Page 51.
You can say it's a clause 21 notice, but it is subject, say, notice for appointment of arbitrator under clause 12 of the terms and conditions.
Yes,
So
my lord.
it must be corrected first.
No, my
before
lord,
the
what?
court.
Clause 12 is the arbitration agreement in the agreement.
Section, there is a note, as such, there is a section.
Kindly see page
21
number
note.
19 of our joint venture agreement.
The last line is enough.
Yes, my lord.
This is a notice under section 21 of the
yeah.
arbitration
54.
and invoking arbitration. That's enough.
Now,
Page 54, madam, last line.
well,
Yes.
why I am mentioning that it's a premature, as per the
Yes.
clause 7,
Yes.
that is page 17, it is stated account and joint venture will be adjudicated at the end of the project. It's very clear cut word, end of the project.
Where?
Now, what is the
Which? Yes.
page 17, para 7.
Page 17, para 7. Accounts of the joint venture project shall be. This is accounts.
And shall be adjusted at the end of the project. This agreement on 15th April 2024.
All that you can.
Petitioner categorically mailed my client.
Maintainability issue before the arbitrator, not maintenance.
My lord, apart from the, why I am saying this the premature, the construction not yet completed. All these photographs are in print, and the CC, which one is partial CC, and my lord.
Go before the
sitting over
arbitrator.
Each code, you know, my lord, mere application making before is not the completion of the all job, because each and every money.
Are you
yet to be
disputing the?
completed.
Are you disputing the agreement entered between the parties?
No, I am not disputing.
Are you disputing the arbitration clause?
Premature.
Go before the arbitrator.
My lord.
He'll decide. It's not arbitrable at this stage. That decision he will take.
Because I have invested the other money, I have and he himself on 14th April 2024
Arbitrators.
project.
Now tell me, there are 3 arbitrators. What to do? One,
One.
with the consent of the parties, I change this.
Yes. Oh, my lord, since it is only the
In Arbitration Act 19,
can it be sent to
1940.
the mediator for mediation small amount?
Wrongly written 1996.
You have done it.
No, not I.
Whosoever has done it,
Yes.
not you. I mean, not you means it.
It's a
I'm sorry, my lord.
since because it's only for the part of calculations. How much they
Yes,
have
tell
paid
me,
as
can I refer it to
by net friendly degree
Lordship.
mediation can
mediation?
That I have to ask, my lord.
You take consent if it can be referred to mediation for the time being.
I will ask.
Explore the possibility.
The calculation.
I will ask, my lord. I
There's
will ask.
nothing remain with
We'll
the
have it on Monday. Come back on Monday.
And not 20.
Section 11 application, Lordship. The arbitration clause is at page 39, volume 1. very small issue, Lordship. It was a contract given for 5 years. Thereafter, it was extended for 2 more years. This was a
Contract given for what?
contract for catering services
Catering.
in the trains, Lordship. Now, the issue
Master
is...
license agreement.
Yes, yes. The issue is, Lordship, there were number of days the trains were cancelled. And my claim is in damages.
Indian Railways.
Yes.
It's IRCTC.
Yes. My claim is in damages, but I was not provided the train. I could not walk, but I have paid for the entire tenure of 6 to 8 years of span. My arbitration clause is at page 39.
Are you disputing?
Only clarification I needed is that there was a section in application where they
Yes.
asked for extension of the period.
Yes.
Which
That
the
was...
honorable division bench said cannot be
Cannot be
extended beyond the
Yes.
contractual period. That
Absolutely.
once they only claim in damages, I have no.
My claim is in damages only. Nothing more than that.
Logically record that the claim is in damages.
Yes, that has been indicated by the division bench also.
Problem of the section.
Where's the
28
order?
is-
Division bench order.
Okay.
What did you challenge before the division bench?
Yes, the section 9 order.
The section 9 they have challenged. Section 9 we got an order.
Section 9 was challenged.
That portion Lordship could find that at paragraph 64.
Who's
73.
raising all these technical objections? You?
No.
Technical objection. No, they
I
obtained an interim order. They are challenging a third party right. A tender
I
in 2024.
would not comment on that.
Person did
But
could not even get into the test after 2 years.
what I could
getting
understand, the jurisdiction was an issue. But I let us not.
the jurisdiction point was also answered in the judgment.
You were raising jurisdiction.
Yes.
I was not there, but
They raised the jurisdiction issue saying it's not a first appeal, it should be admitted.
could have been
All
a
those-
section 37. But I let's not go into that.
Paragraph 67 onwards is the question has been answered, and the 74 is 77. The appeal was allowed, and the ex parte ad interim order was vacated. I'm showing this only because in section 21 notice they raised the issue of extension. That's why, if that is restricted to damages, I have no objection to go further.
Nothing more than that. What can I? 589 days it was cancelled. In that during the period, my claim will be in damages. 589 days is quite a lot of time for a contractor in that entire 8 years period.
21 notice.
Is at page 220, volume 2.
All your facts are there.
Yes, madam. Yes, madam.
220.
220. 220.
Mr. G.
On-board catering service in train number 1287. Person to award. Declared successful bidder. It's providing catering service. Take down the Present application has been filed under Section 11(6) of the Arbitration and Conciliation Act, seeking appointment of an arbitrator for adjudication of the dispute arising out of the catering license agreement. Catering license agreement. Agreement executed between the parties in respect of on-board catering services in train number 12871/12872. Page number 220. Dated, what is the date of this contract?
21st May 2014 it was awarded.
21st May 2014.
Letter of award.
That's a letter of award. That's okay. Dated 21st May 2020. 2014. Full stop. Learned counsel for the petitioner submits that pursuant to the tender conducted by the Indian Railway Catering and Tourism Corporation Limited (mein IRCTC), the petitioner was awarded the catering license in respect of the aforesaid train for an initial period of 5 years. It is submitted that upon expiry of the original term, the license was renewed for a further period of 5 years, and the renewed term was scheduled to expire on 9th February 2026. Petitioner submits that during the subsistence of the license agreement, the train remained cancelled for 589 days or 1179 trips during the tenure of the said contract. Reasons: 589 days did not, and the petitioner could not operate on such days, leading to substantial losses. Full stop. Learned counsel for the petitioner submits, though he could not operate on 589 days, but had paid the license fee for the entire contractual period to the respondents. It is contended that it is contended by the petitioner that he is entitled to a corresponding extension or appropriate contractual relief. Full stop. It is further submitted that despite repeated representation, extension of the license period to compensate the lost operational days was not granted by the respondent. The petitioner had filed a Section 9 petition before the City Civil Court at Calcutta as Miss Case number 1556 of 2026. What was the interim order which was granted?
That is what they referred it in page 221, the third paragraph in that page. The petition section 1 notice records the obtained an interim order of injunction restraining opposite party from taking any steps in respect of a new tender that was arranged to open on that. That was the interim order obtained.
The petitioner obtained an interim order restraining the opposite party from taking any steps in respect of the new tender that was alleged to be opened on 15/4/2024. Full stop. Learned counsel for the, that is the main thing, right? Anything else?
Nothing.
Learned,
This has been repeated.
Learned counsel for the petitioner states that he confines his relief only to the damages for not being able to run the operations for 589 days in terms of the contract executed between the parties. He states that he shall not press for the extension of the contractual period for which he was unable to operate in terms of the contract. Full stop. Learned counsel for the respondent states that since the petitioner is confining his relief only to the damages for not being able to run, not being able to provide the services for 589 days in terms of the contract, and is not seeking extension of the said contract or extension of the said contract, full stop. Comma, the respondent does not oppose the appointment of the arbitrator. The full stop. The counsel for the respondent inter alia admits the execution of the contract and the arbitration clause as contained in the agreement, and consents to the appointment of a sole arbitrator to adjudicate the dispute between the parties. In view of the same, this court appoints, given him.
We both give two names because it will be embarrassment
one?
for Lordship will decide anybody.
Both of us giving.
Yes, so I cannot.
Both senior advocate, Lordship will decide.
Decide anybody after.
You should have decided on your own.
It is. Both are senior advocates.
Only thing is the name that we have given that already is doing one arbitration lot for IRCTC.
Ritzu Ghoshal, senior advocate, as the sole arbitrator to adjudicate the dispute between the parties. The learned sole arbitrator shall enter reference in due compliance of section 12(5) of the said act. The learned arbitrator shall be entitled to fix his remuneration in terms of the fourth schedule of the act or with the consent of the parties. All issues pertaining to maintainability, arbitrability, limitation shall remain open to be adjudicated by the learned arbitrator.
Grateful.
Yes.
Number 21. Lordship, I am praying for not to delay.
Last time also you prayed for not to.
If the senior advocate is suffering from fever, Lordship,
Last time also your senior
so
advocate.
kindly
Who's your senior advocate?
Ravi Shankar Sattvathai, Lordship.
Last time also same.
So kindly, Lordship.
When was the
Last
matter
time.
listed last time? I remember. You asked for the
Last.
same relief. Same
This is
prayer.
the last time, Lordship, kindly.
In June also the same. July also same. August also same.
Lordship, kindly give me one chance, Lordship.
Learned proxy counsel, so and so states that the main arguing counsel is indisposed. She prays for an adjournment. Let this matter be adjourned to when? When do you want? Any day means what?
Next week, Monday or Tuesday.
Wednesday. Next Wednesday.
Yes, Lordship. Next Wednesday.
Advance 22.
Section 11 application, Lordship, I believe my learned friend has taken the point of jurisdiction saying Venue is New Delhi. Lordship, immediately I can withdraw and file in New Delhi. There is no difficulty. But
Then you
since
should do it immediately.
I'll
Giving any difficulty.
I'll say something, Lordship. This can be resolved. What I could find from the facts, it's a minuscule fact. A tender was awarded. I had to deposit the security deposit. Lordship, listens to me for 30 seconds. 30 arbitration will not be required. A tender was awarded. I had to deposit the security deposit within a certain time. I deposited 2 months late. That's the issue. They have terminated. My learned friend is here. Let him use his good office to resolve this. There's nothing more than that.
If I do that, it amounts to entertaining the
No,
petition.
I will not ask you, Lordship, for any prayer. I am saying if my learned friend can go, because there's no issue. I go to Delhi and get an arbitrator appointed. Nothing will any to my learned friend benefit also. it is beneficial for both the parties.
That you should have decided outside the court.
No, I told him, I told, I told him, I told his junior also that what is
Switch of instructions.
it's a minuscule of a thing that a security deposit was deposited 2 months delay.
I may talk with my client, but that doesn't get a.
No, I am not saying that
No,
jurisdiction.
we are
I am
giving
not
it.
saying that.
It's admitting to that, but
I'm
just
saying
make an effort, see if you can.
both the matter is just that issue, nothing more than that.
Miss,
58 lakhs security deposit was paid 2 months delay. Admittedly 2 months delay.
Make an effort. If it can be resolved, it can be resolved.
I'll talk to the guy. I'll talk to the counsel.
I'm not passing any order.
No, I'm not saying that also.
Neither
Because
I'm referring him to mediation, nor I'm passing
nothing. Let my learner use his good
notifying
office.
it. We'll keep it. Otherwise,
Yes. Otherwise, I will go. Otherwise,
Yes, this minute I'll have a word with my clients. But in the meantime, we'll dispose this document. Doesn't keep this pending. Because in any event, doesn't any to anyone's advantage.
if I dispose it off, your client will not even take your call.
Right. That's exactly.
That they will not. That they will, because IRCTC will not. Number of issues.
Believe me.
It won't ever. Otherwise, litigation will go on.
Here,
that I'll leave it to you.
Then they will respond to you.
I'll leave it to you.
22 and 23. Otherwise, I would have, because I felt that this is an issue which.
How much time? 10 days?
10 days.
Next Friday? Next
20,
Friday?
yes.
Next Friday is what? 8 can.
Keep it on 29th.
29th. All right, 29th. 29th.
22 and 23 same.
25 to different. But do make an effort.
That is why I thought that I will say otherwise.
Agenda 24. But everyone we have the petition, I prefer not to.
Not today.
Yes.
$25. If you for the respondent, again a point of jurisdiction.
Here the issues are quite
So you
cumbersome.
withdraw it.
Lordship will keep it tomorrow.
Why?
I'll just
That's a
take
better
my
day.
client's instructions and here the issues are different and cumbersome issues because this came up in the newspaper also.
Thursday. Oh. Withdraw.
That's one of the points. This cumbersome sense that there was only one clause venue. Now there is a clause for venue in this as well as.
No, I'm not talking about the
jurisdiction.
jurisdiction. I'm not talking about jurisdiction. Issues are factual issues are different. No, I'm not.
Thursday, I can't have it tomorrow.
Day after, if you, I'll just speak to my client once and I'll withdraw and file.
Monday.
Tuesday.
No, Tuesday can't. Monday. Tuesday is non-commercial.
Monday or something. Wednesday, Lordship.
Wednesday.
I guess.
Great.
26.
Was an earlier order passed by my lord, wherein since the section 21 notice was not properly served,
Yes.
my granted liberty
Yes.
to file an application. The arbitration clause is at page the arbitration agreement starts at page 12A, annexure A, and the relevant arbitration clause is at page 14, my lord.
You have issued the fresh notice, right?
Section 21 notice is at page, my lord, they have received the section.
Yes, sir. Yes.
Section page 70.
Are you objecting to the?
Page 70, my lord, your lordship's order.
Yes, I've seen page 70. I know what I've given him liberty to issue a fresh notice. Yes, tell me.
My lord, observed it.
No other thing, sir.
Stated that the arbitration agreement may in certain circumstances bind legal representative.
Legal representative can file it. You are appearing for the legal representative? Yes, they can file it. Are you disputing the agreement? Obviously not.
Agreement, my lord. Agreement it is not within our personal knowledge.
All right, now it is within your personal knowledge.
In our personal knowledge.
Yes.
consent, the question of consent in this arbitration.
No, sir, the question of consent is not necessary here. It is legal as.
I am not on that base of the venue of arbitration.
Yes, venue is what?
Venue of arbitration is Kolkata.
Yes.
The jurisdiction of Kolkata court.
Yes.
In kindly terms, para arbitration agreement with para 20 and 21.
Page 14, my lord. Arbitration agreement starts at page, the arbitration clause is at page 14, my lord.
Yes.
The award of the sole arbitrator shall be final and binding upon both the parties therein. The arbitration proceedings shall be held at Kolkata and the language of proceedings be English.
Yes.
My lord, in this context, my lord, I submit that, my lord, section 20 of this arbitration and conciliation, and there is two ingredients, my lord. One is consent of the party, and another is the convenience. It has been stated, my lord. And in that case, my lord, in this case, we no not sort of given in personal consent to this clause, and my lord, this place of arbitration is not convenient for us. Because we are physically challenged, one of the challenge, temporary challenge, but it's inconvenient for us for traveling. So,
Can't be changed. I can't change the terms and conditions of the contract. Can't be done, sir. And it is represented through a lawyer. They are not coming by themselves. They are not appearing in person.
what the purpose of
I can't change the terms. If it is Calcutta, it is Calcutta. I can't change the venue. This court has no power to change the venue. The consent is already there. Consent is by your father. Yes.
And the company,
Whatever it is, sir, you file a transfer petition.
May I file my affidavit of service, my lord? I'll keep to the record.
If you are disputing the agreement or the arbitration clause, then it's a different thing. If you're not, then you raise all the issues before the arbitrator, whatever issue they are. You are representing all the legal aids? There is an application filed under Section 11(6) of the Arbitration and Conciliation Act, seeking appointment of a sole arbitrator to adjudicate the dispute and differences which have arisen between the parties under the dealer agreement dated 7th December 2015. This is the second round of litigation between the parties. Full stop. The petitioner had earlier filed application under 11(6) of the Arbitration and Conciliation Act, being APCOM number 154 of 2026, seeking appointment of an arbitrator. Full stop. This court-wide order dated 1st April 2026, the said application was disposed of. The operative portion of the order reads as such. Page 72. Full stop. While disposing of the earlier application, this court held that the notice invoking arbitration dated 20th September 2025 had not been duly served upon the respondents, who are the legal heirs of late Samir Kumar De, the original contracting party to the dealer agreement dated 7th December 2015. Full stop. Accordingly, liberty was granted to the petitioner to take appropriate steps in accordance with law. full stop. Pursuant thereto, the petitioner issued fresh notice invoking arbitration dated 5th May 2026. The petitioner has placed on record copies of the postal receipt and tracking report, which prima facie indicates that the said notice has been delivered to the respondents. Learned counsel for the respondents appear and does not dispute the execution of the dealership agreement dated 7th December 2015, full stop. The said dealership agreement contains an arbitration clause, and the said clause is not disputed by the learned counsel for the respondents, full stop. This court in section, the scope of section 11 is limited to the extent of examining the valid existence of an arbitration agreement as well as an arbitration clause as contained in the said agreement, full stop. Prima facie, this court is of the view that there exists a valid agreement between the parties and the said agreement contains the arbitration clause, full stop. In view of the same, this court appoints Mr.
I have talked with my
Give any name.
Oyon Banerjee, my lord,
Mr. Ayan Banerjee as the learned sole arbitrator to adjudicate the dispute between the parties. Full stop. The learned arbitrator shall enter reference in due compliance with section 12(5) of the said act. Full stop. He shall be entitled to fix his remuneration in terms of the fourth schedule of the said act or with the consent of the parties. All points related to arbitrability, maintainability, claim, counterclaim shall remain open to be adjudicated by the learned arbitrator. Wakalatnama filed by the respondents is taken to the court. Last line. With the aforesaid direction, the present application stands. Petition stands allowed.
Section 9, item 27.
My lord, these two matter, item 27 and 28. My lord, we have taken last occasion time to take instruction because the fact is this, my lord, these two are section 9 matters and our section 11 was pending. Now they have in their opposition, they have taken a point of maintainability of the section 11 on technical ground. So we withdraw those section 11 and we have given a new section 21 notice. Now they have recently has given a combined answer to all the section 21 notices, and what they're saying that they have a claim against the sister concern of this company and they want that to be go to arbitration. My lord, I have taken time to take instruction. My lord, I need some further time. Kindly take this matter on next week, my lord. I will come back with the instruction, my lord.
Only that why we are will kindly permit the urgency on our part, my lord. Firstly, my lord, in the next item, that's item 28, there's a substituting interim order in the section 9. We have throughout said, my lord, let this be remanded to the arbitral tribunal.
My lord,
Let it be decided.
Make it a last
one more. Yes, because this is the third time they're seeking an adjournment. Even on Monday, my lord, we'll recall there was a resolution. That's why I couldn't press for anything to be done. But my lord, there's no intention, it seems, on the part of the petitioner to arbitrate, which is the fundamental.
It is not, my lord. What my learned friend is saying, he has a claim against my sister concern.
No,
so
no,
he
not only
wants
that.
to, very well, he
Anyway,
wants to that
we may
claim
not-
to go to arbitration, my lord. To that, either
Wants both the claim to go to arbitration.
Yes, all claims composite, and it's their own section 21. It says it's a composite transaction. Here, my lord, really these two applications.
So then we can refer it,
Yes.
take consent from your client.
yes, my lord, we are trying to, because what is happening,
In section 9, I'll appoint.
Yes,
that's
My
why
lord,
we don't,
record the
perhaps we
consent,
don't,
yes.
do not have
Consent
to.
of the parties, I'll appoint.
That's why I was trying to
Section 9
take
will be
instruction, my
treated
lord.
as
There are
section
some,
16 before the learned arbitrator.
yes, my lord, this section 9 will be, my lord, can be, my lord,
17, if they want to
treated
tell
as
us,
section
can be done,
17
no
also.
difficulty. And we will have our remedy as well. Because
So
we
my lord,
written to
kindly
them,
make
we
it
indicated.
next Monday. I am not praying for a long time also.
But as a last chance,
Yes,
we might
yes.
pray, my lord, if it comes.
Not recording anything.
I appreciate, my lord, if my lord will kindly at least allow me to refresh my lord's mind, because this is the third time they're
No,
seeking
on Monday we will not ask court time.
My lord, if that
Monday
is
or it is
understood, I am not
when you
taking.
Monday.
Wednesday,
Whenever
My
you
lord,
want.
Monday, if it comes. So, my lord, Monday, my advocate record would have Monday.
very,
Okay.
I don't have.
My lord, this is that matter, my lord, under the MSME Act, my lord, where my lord I had placed that judgment on the last occasion that my remedy has become. Kindly
is
see
your
the orders,
counsel?
my lord. Kindly see.
Where is your counsel?
He is out of station, my lord.
Every time he comes, he misleads the court, makes a statement. Last time also he made a statement that hearing is supposed to be scheduled before the council. Then he disappears. I see him online, then he disappears. What is this?
Unconditional
What kind
approval.
of
My lord,
approach?
I have been instructed to not to do in this matter.
And after 4th February order of my lord, where my lord has actually taken them to task, my lord, after that same thing is being repeated. Such
Some
impunity.
people don't learn. Not today.
Next.
We'll have it on Monday. You please ask him and tell him this conduct doesn't reflect very nicely on him. Reflects very poorly. You are a young counsel. I'm not saying anything. Please tell your senior.
Yes, ma'am.
29.
30.
Your Lordship, appearing on behalf of the respondent.
Ma'am,
Your Lordship, there was a specific direction to submit affidavit regarding on the points of jurisdiction.
Lordship, in this matter, we have taken that the jurisdiction point, the agreement states that the agreement has been concluded in Kolkata. But Lordship, their defense was that everything was in Delhi. Lordship, accordingly, we had taken the arbitration clause states that where the agreement has been concluded, the arbitration will be happening there. And therefore, we have done the section 9 here. But Lordship, we could not satisfy on the point that any cause of action has arisen here.
Correct.
So, Lordship, I leave it to your Lordship. That is
Withdraw it.
Lordship, I do not have the instructions.
Then I should dismiss it.
Yes.
On the game of territorial jurisdiction.
Yes.
You have filed your reply.
I have filed my reply. I have put in my and I have taken that point because all the documents were executed on an electronic mode. It was never executed.
Lordship, the digital stamp also says that it's in Kolkata.
Stamp is just fixing at Kolkata. Disbursement made from Barakhama in Uttar Pradesh. Kindly see page 29, Your Lordship. Your Lordship, just kindly page 29, clause 9. It is enough to
Lordship,
satisfy.
and our point was only that when the agreement was signed, both the parties were aware that the agreement is being executed at Kolkata, which is at the first page, page number 19. So they have 19. Lordship, the first page says this agreement is executed at Kolkata. This is something which was in the knowledge of the borrower itself.
Your Lordship, it only says executed at Kolkata, but it is a clause 9 itself says parties hereby acknowledge and agree for the electronic execution of this agreement, and it has been signed electronically.
Electronically signed by them in Delhi.
In Delhi, disbursement made from Delhi, performance of the contract made in Delhi.
But concluded in Kolkata, signed by us in Kolkata.
You have electronically signed in Calcutta?
Yes. Electronically. Lordship, my stamp says it. Lordship,
where do you get that?
Your
Lordship signature signed by Atul Kishan Kantak, loan agreement, location Kolkata, date. In all pages, Lordship, at the right-hand side.
Lordship, digital signature.
Lordship, digital signature. If the stamp says
the digital signature which you have done.
Yes.
From where? Where's the computer? From where have you signed this? File an supplementary
Yes,
affidavit.
Your Lordship, only on this point only there was a direction, but they have failed to file any.
They will file it. How can they?
Already there was a direction in this regard, wide order dated 27th April 2020.
Lordship, I am submitting that the
It doesn't matter, madam.
Lordship, I am submitting that the computer was in the branch office of my client and it was signed from there.
Bring it on record. File an affidavit. Learned counsel for the petitioner shall
Your
comply with the directions passed
Your
by the
Lordship,
court
just
dated
I want to
27th
take
April
paragraph 3 of
2026.
their application. Paragraph 3 of their application, Your Lordship.
Paragraph 3.
3. The parties enter into an agreement on 29 December 2023 at your petitioner's previous Kolkata branch office at 5th floor, Srijan Park, Sector 5, City, Kolkata 91, which is not within this jurisdiction. And the pecuniary jurisdiction, their claim is only 20 lakhs. So pecuniary jurisdiction is also not of these.
So let them file the affidavit. You file the affidavit, man.
Lordship,
Comply with
the IP address will track down to Gurgaon. I'm submitting, Lordship.
File it. I want it on record.
Lordship.
File it on record. IP address tracks it down to Gurgaon, makes my life easy. Since you're not making my life easy, I'll make my life easy.
Lordship,
So you're not making it easy, so I'll make it easy. I need material.
The application.
I will dismiss the application based on facts.
Lordship.
So that I get that IP address, which is your Gurgaon office from where you have signed it. Makes my life easy. Since you're not making it easy, I'll make it easy for myself.
My client is not making it
No,
easy.
but your client should be put to task.
Yes, Your Lordship.
He should be put to task, and I'll do that.
Multiple forum shopping.
I will do that.
No, we did not do multiple.
No, I'll set your client right. Just let me get my house in order. I'll set your client right in this case. You file an affidavit.
Lordship,
then I will dismiss with a cost, an exemplary cost, and I'll say how you were trying to mislead and how you are doing the forum shopping. Your client, not you, Miss Shrejani, not you. Why do you take it personally? It's not you.
Your Lordship.
It's your client.
Bow down to Your Lordship.
If your client is acting smart, he should be taken to task.
Yes.
If the digital signature comes down to Gurgaon, take it from me and tell your client, I will dismiss with exemplary cost. And I'll pass directions against your client that how he's misusing the forum and he's indulging in forum shopping. They think they're smart.
Lordship,
I know how these financial companies function.
Lordship is keeping it to.
And then you also tell him, we'll get a 340 filed by her. I'll call your CMD and I'll ensure your CMD goes to jail. You please inform him.
Lordship, I'll inform this.
You know, and I'm sure this is recorded.
Yes.
This is how you are misleading the court. So unfortunate. And they have the cheeks to say, don't withdraw it. Fight it out. Despite the fact that they know where the contract has been concluded. The digital footprints will show it has been concluded in Gurgaon. And they want this forum to entertain it. Everything has been done from Delhi.
Yes.
And NCR. And they want this forum to deal with it. I'll take them to task.
I'll send the message.
Yes.
2026, bringing on record the digital signatures which have been affixed on the agreement. The details of the digital signatures which have been affixed on the agreement indicating the location from which it has been digitally signed.
Lordship is keeping it returnable.
Returnable after, you tell me, 1 week? 2 weeks?
1 week.
You file your affidavit?
I hope after this, they will give the necessary instructions.
After 2 weeks, we'll get. Weeks.
Thirty-one,
Your Lordship, on the last occasion, Lordship put a query to my learned senior whether they want to withdraw or get the application dismissed. Of course, that's Your Lordship's domain. I don't want to enter. I only want to assist Your Lordship with some edifice, if I may call it so, to pass appropriate orders. I am citing one judgment passed by a coordinate bench of Your Lordship. Right, sir? Your Lordship, this is 2023 SCC Online 2734, before I can just refer to this, your lordship, I had indicated to your lordship that the arbitration clause enumerated that the place of arbitration, which would also subsume the venue, would be the place where the agreement has been signed. Lordship, it has been signed, executed outside the original site jurisdiction of this honorable court. Apropos that, your lordship will kindly allow me to place paragraph number 3, in fact, at page number 2. Learned counsel appearing for the petitioner opposes the point of maintainability on the ground of jurisdiction to say that parties intended the seat of arbitral tribunal would be in Kolkata, and that the words in bracket are only meant for convenience of the arbitral tribunal or the parties for.
Let I hear what are your instructions?
Lordship, similar instructions, Kolkata.
Your Lordship, over here, same issue. Kolkata, Your Lordship, cause of action arising out of the outside the original site jurisdiction of this honorable court, held that this jurisdictional civil court has to be approached. I will indicate the paragraphs. Your Lordship can. I would find no use wasting your Lordship's time over this. Paragraph number 3, 4, Lordship, 10, which is the issue which is absolutely same as ours. Your Lordship, I will just place this part. Issue which falls for consideration on the point of maintainability is whether the parties intended that the seat of arbitration would be the place where the contract is issued, that is Salt Lake City, Kolkata, or the courts in Kolkata in general. If the respondent is correct, then High Court would be divested of its jurisdiction to hear the matter, and the application must be relegated to the commercial court at Rajarhat. Your Lordship, with respect to this issue, Your Lordship, 11 is the jurisdiction with respect to when the general usage Kolkata is appended in the arbitral clause. Then Your Lordship, section 3 is noticed in the subsequent paragraphs. And Your Lordship, if Your Lordship comes to the operative portion, which is at paragraph number 19, Your Lordship, I'll just place this particular paragraph. In the present case, the arbitration clause in the GCC and the work order specifies that the seat of arbitration shall be Kolkata, but clarifies that the seat will be placed from where the contract is issued. Your Lordship, over here, there is no clarification to such clause. It simply says that the arbitration will happen where the contract is issued, which is outside the jurisdiction. The ordinary and plain meaning of the clause, with due weightage given to the intention of the parties while inserting this clause, post-amendment cannot and would not point to any construction besides holding that the parties intended to seat the arbitration at the place from where the contract is issued. Entire contract and documents, including the NIT and correspondences, including the termination letter, specifies in a box at the bottom of each page of the place of issue of the contract, which is the address adduced, Salt Lake. As such, Your Lordship, commercial court at Rajarhat. Same facts and circumstances. These are my humble submissions.
You have one judgment, any other judgment?
No, one judgment.
Lordship, can I consider this and come back?
Same.
Your Lordship,
Same day. We'll have it on the same day. ये दोनों साथ लगाना matter. Same order. Not same order. Just same day. At the request of the parties, let this matter be listed on same day.
Would Your Lordship kindly allow me to file the wakalatnama, Your Lordship? My instructing advocate is not here today.
File it in the register.
We'll file. I'll request him to file. Grateful.
32.
My lord, and this is that matter, my lord, where after entering appearance, they have raised a point of jurisdiction, my lord. Their contention is that, my lord, the agreement is executed outside the original site. So therefore, my lord, this coast is divested of his jurisdiction, my lord. My lord, I have, my lord, 3 submissions, my lord. If my lord says no, it's already unless they want to re-argue, they have argued.
Yes, I want to make one, Milord.
Mr. Chakraborty has argued, and I was to respond.
Because, Milord, there is 2 arbitration applications before Your Lordship. One is the mother arbitration application, where Your Lordship has been pleased to pass, Milord, an order by which, Milord, the bank accounts of the respondent are frozen up till rupees 37 lakh. The difficulty which it is causing, Milord, is that we are unable to do our regular business. But it is, Milord, an order which Your Lordship has passed post an award. The award may we could not serve. These are all contentions.
Put
But
a bank
we have-
guarantee, put a cash.
Yes. So my first application is, Milord, with an alternative prayer that Your Lordship's order will be, Milord, solemnly followed. If it is replaced, Milord, with an equivalent bank guarantee, I would, Milord, be most humbly, Milord,
Yes.
my clients would be in great relief.
Let them deposit the money.
Yes, yes.
Yes.
My lord, the bank guarantee, my lord, that's my specific prayer in my
That is
application.
GA1.
GA1. That can be disposed with this prayer.
Yes, yes, my lord.
And
But
the
no
next
bank
limb, my lord, is with respect to territorial jurisdiction.
that I am
The word Kolkata is used. But my lord, that will
there are
take some time.
judgments, my lord.
I will, my lord, try to, my lord, impress upon your lordship.
I have no
my lord.
difficulty.
If lordship can take that up on Monday, we will argue that point because this is always coming up before your lordship. I was pleased to do two matters where your lordship has held in my favor as far as the interpretation of Kolkata is concerned. But my lord, I think GA1 can be disposed.
Let them deposit money.
With equivalent bank guarantee. Lordship will see
So let
my
them
prayer.
deposit cash, my lord.
I'll give it.
My bank guarantee is, my lord.
I'm sorry, my lord. Please, I apologize.
My request is for bank guarantee. That is my prayer.
This is an application filed by the respondent seeking recall or modification of the orders passed by this court dated 17th December 2025 and 28th January 2026, whereby the bank accounts of the respondents were attached to the extent of 3708713. Full stop. Learned counsel appearing on behalf of the respondents submit that at the outset that this court lacks territorial jurisdiction to entertain the present proceedings. Full stop. It is contended that the respondent is situated in the state of Odisha.
My lord, the petitioner is situated in the state of
petitioner is
Odisha and we are outside the jurisdiction.
Situated in the state of Odisha, and that this court lacks the territorial jurisdiction to entertain the present petition. According to the respondent, no part of the cause of action took place within the territorial jurisdiction of this court.
Yes.
Full stop. It is further submitted that the arbitration agreement stipulates Calcutta as the place and venue of arbitration, and in the absence of any part of the cause of action having arisen within the territorial limits of this court, the present proceedings are not maintainable. Right?
Yes, ma'am.
Full stop. Learned counsel for the respondent further submits that respondent had no prior knowledge of the arbitral award dated 7/11/2025 and came to know about the same only on 23/2/2026 upon receiving intimation from HDFC Bank regarding attachment of its bank accounts pursuant to the orders passed by this court. It is further submitted that respondent is a proprietorship concern and the continued attachment of the bank account hampers and causes serious prejudice to its day-to-day operation and financial transaction, thereby resulting in irreparable loss and injury. Full stop. Learned counsel for the respondent submits that he is ready and willing to comply with any terms and conditions as may be imposed by this court for securing the awarded amount. This court has considered the submissions advanced on behalf of the parties. From aside, the arbitration agreement designates Calcutta as the seat and place of arbitration. Full stop. The present dispute also falls within the ambit of a commercial dispute involving a claim of 3708713. In view thereof, this court is satisfied that it possesses the requisite territorial jurisdiction to entertain and adjudicate the present proceeding. Full stop. Having regard to the submissions advanced by the learned counsel for the respondent, and in order to balance the equities between the parties, this court deems it appropriate to direct the respondent to secure the amount of rupees 3708713 by depositing the same by way of a cash security with
Blood,
the
a bank guarantee would be blood.
cash security with the registrar original side of this court within a period of 2 weeks from date. Full stop. Subject to such deposit being made within the stipulated period, the order dated 17/12/2025 and 28/1/2026 shall stand recalled, and the attachment levied upon the bank account of the respondent shall stand vacated.
Lordship has given us
2 weeks.
Can we kindly
week?
have 1 more week extra?
3 weeks. 2 weeks ko 3 weeks kar do.
And may I get
Default of such deposit being made within the stipulated period, herein above, the interim order dated 7/12/2025 and 28/1/2026 shall continue to remain operative without any further reference to this court. With the aforesaid direction, the present application stands dismissed.
My lord, only one humble request, my lord. In their main application, we have, my lord, opposed also on the ground of jurisdiction. Your lordship has expressed a prima facie view at the time of final argument.
That is how I am entertaining it.
Yes.
If I don't express a prima facie view, I can't pass any orders.
Yes, that is how.
My first order, my second order, my this order, every order goes. You want me to change it?
No, no. My lord, one humble request, my lord. Your lordship, my lord, has used the word Calcutta. My lord, actually, after 2001, my lord, Calcutta doesn't have.
Kolkata.
We also felt very sad when Calcutta was changed to Kolkata. I'm deeply obliged. But maybe file, my lord.
Section 9 will, we'll have section 9 on some other day.
But maybe file our affidavit in reply, my lord.
Affidavit in reply to
the
section
GA1. GA1.
GA1. Affidavit in reply. GA1 is disposed of, just take the affidavit in reply. First line in request. Affidavit in reply filed by the respondent is taken on reply.
In the main section 9 application, maybe use a short affidavit in opposition because it's coming after some time.
Section 9 mein karo.
That is APCOM.
APCOM 950 of 2025. Learned counsel for the. There's an interim order, right? This is protected.
Yes,
that interim order, your lordship,
Yes, that's what I'm saying. That's protected.
Yes.
So 37 lakhs, whatever it is.
Yes.
08513. So learned counsel for the respondent seeks and is granted 2 weeks.
2 weeks.
2 weeks to file his affidavit in opposition. Reply to the same, if any, within 1 week thereafter. List after 4 weeks.
I'm deeply obliged.
The rest of the matters,
Lordship, for the next matter, I will be taking time, Lordship.
what time?
Lordship, in this matter, a Section 8 application is pending in Barashat Court, which has not got.
Who's on the other side?
Lordship, the last order also records, Lordship. Today, Lordship, this has not got finally
Take up.
decided.
Learned counsel for the petitioner states that the application under Section 8 of the Arbitration and Conciliation Act is still pending before the court at Barasat. And she prays for an adjournment. Let this matter be listed in the monthly list of September.